CRMDB.
Bail application.
Bail application. Why it was this? When it will be applicable, the restoration will come out. Be ready to move in matter of minutes. Right. Give it. On the list.
Item number 1. For correction options. On 9th January 2025, Honorable Justice Kabul was passed an order. There is some correction. Only
We make the corrections.
page number 3, last paragraph. Admittedly, the petitioner had joined service only on 27 August 2009 and had completed 6 months. It should be 6 years, 6 months.
6 years and 2 days.
6 years, 6 months, 2 days.
Anything else?
No, Lordship.
Typographical error. Page 3. Last paragraph. The words 6 months and 2 days be read as 6 years, 6 months and 8 days. Then other portions. Yes, call the next matter.
Item number 2.
Item 2.
Yes.
The petitioner's name classified from a confessional statement of the principal.
How long you are in
25 days. However, it did not lead to any recovery after the confession.
which was clear?
Yes.
Ballard.
Item number 2, not a case diary.
Not today. Next.
Item number 3.
Yes.
The allegation is under section 22C of the PSS. The petitioner is in custody for 611 bottles of fentanyl.
What is the stage of the proceeding?
Trial has not been.
The trial of commenced next date for evidence third February.
How many witnesses examined? How many witnesses examined?
No, Lordship, not a single on the
How witnesses examined?
on November, Lordship.
All right.
On 26 to 29 November, schedule was fixed, but not witness was examined. Next date for evidence third.
Why?
If the absence of your Lordship on leave, you are on leave.
What is the total seizure?
Consider 11 bottles of fentanyl and 282 capsule. 282 number of capsules.
11 bottles.
Only
And
one
282, but 282 piece of plasmoxoxybate and 280 piece of another tablet. And Lordship, on 5th November 2024, another co-accused bail petition was rejected by the court in session.
Third January, there was a rejection. Nobody appears. 5th November, there is no rejection.
Yes, Lordship.
5th November
It was another accused, Lordship.
is another idea.
Actually, the petitioner's bail application was only once moved. It was on 14th of May.
May.
Yes.
And Jawad Mansari's was rejected twice. That was on 14th of May as well as 1st of January.
Jawad is not reported.
Correct. That was dismissed for default.
In my city, Lordship, there is a 5th November, bail petition was rejected.
Please give us the number, CRM DB number, or CRM LDPS number.
That personal.
I was.
Next.
Item number 4, I am for the petitioner lordship.
I want to say.
Litigation is under section 6 of the POCSO Act, lordship, the plaintiff has not been served.
Next.
8,
Not I for the petition. Charge under section 80 and 85 of the BNS.
Very good. How many years after marriage?
5 years.
5 years. So you are in custody for how long?
Not for 100 days, not charge sheet has been submitted. All other.
How did she die?
Drowning.
Due to drowning, lordship, but apart from that, there are external injuries on her body. Lordship.
External injury.
Injuries are there, lordship.
The injuries are around the neck with crescentic marks.
Lordship.
Petitioner is the husband. He contends that the
She has tried several attempts but before this.
correct, sir, but crescentic marks are not indicative of any act of suicide. When you have crescentic marks around the neck, it is more indicative of an act of throttling.
She died of drowning, but that is.
Correct, so there was an attempt to throttle her, maybe then she was pushed into the water. You don't know exactly, for you to explain. Petitioner is the husband, he contends his wife had died due to drowning, he pleads for investigation is complete, it's going to be non-employee, the state opposes the prayer, she submits. Victim wife was subjected to torture over demands of dowry. PM report shows marks of injury around her neck, which is indicative of physical torture prior to her death. We have considered the materials on record. Statements of witnesses show petitioner and other in-laws and subjected the victim to torture over demands of dowry. She suffered unnatural death within 5 years of marriage. Injury around the neck. Postmortem report shows injuries around the neck. Though postmortem report shows death is due to drowning, there are crescentic injuries. There are crescentic abrasions in and around the neck and shoulder, which is indicative of physical assault and use of force. Under such circumstances, we are of the opinion this is not a fit case to grant bail at this stage. Next. Injuries.
An earlier official's lordship turned down the bail application on 22nd May 24.
Yes, but then there is no progress in the matter since then. What has happened thereafter? What has happened after petitioner is in custody for 184 days, he renews his prayer.
Not first time, anticipated.
Oh, this is anticipated. 184 days, he praise for bail and a lawyer for the state submit victim suffered grievous injuries. We have considered the materials on record. Injury report discloses grievous injuries. However, petitioner is in custody for a considerable time. Investigation is complete. There is little possibility of trial concluding in the near future. Whether the near future custodial there is no chance of abscondence according to the unindicted plan. Next.
Then
Satisfaction.
Matter was taken up and matter of directed the advocate on behalf of the state bring any whether any dying declaration was recorded or not.
Yes.
What's the item number 10? I have to state your motion.
Madam, this is allegation, madam, 85, 108 and 3 of the PNS, madam, 198, madam. Petition was general, petition is the husband, madam, I am in custody about 97 days, madam. She committed suicide by hanging, madam. Madam,
Within 9 months.
Yes,
madam.
Within 9 months of marriage,
After my
What?
charge sheet submitted, there is no injury, madam.
164 statement of
Here consider.
mother and brother is there.
Statements of witnesses show victim wife was subjected to torture over demands of dowry. Petitioner is her husband, tortured by her husband and in-laws over demands of dowry. Petitioner is her husband. In light of the aforesaid circumstances and the offense, we are not inclined to grant bail at this stage.
I'm good.
Next.
11. Chief Montreal, 506, 34 of the Indian Penal Code. Petitioner here favor stand down, thereafter signed the report.
How long we are in custody?
And custody about 42 days, madam.
Petitioner is in custody for 42 days. He contends that the incident was occurred on the spot of the moment and it was not a premeditated one. Learn a lawyer for the state submit injuries are grievous.
One of the
Injury is grievous and another simple. One of the injuries are grievous. We have considered the materials on record. Incident occurred on the spur of the moment. Whether injuries are life-threatening may be assessed at the appropriate stage of the investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to grant bail, meet investigating also once in a while. Next.
Owner of a commercial vehicle.
Yes. What is the statement of the appeal? The
driver, no allegation against the owner. The IO said he wrongly, they have mistakenly not added the party as a owner, though they have sent a notice to appear before and subsequently the name of the
driver statement recorded.
Yes, Lordship.
What does he say?
They have nothing say about the owner of the.
How did he load the gaja?
At the truck here.
We know at the truck, but from whom did he buy the gaja? How did he load it?
From Assam to
Correct. From where? How? Who told him to load the gaja? Gaja didn't drop from heaven, did he? Then
Lordship, they have stated, may I read the questions? জিজ্ঞাসা বলতেছি আমি পুলক দাস বয়স 24 বছর পিতা রবি দাস গ্রাম সার্চ এন্ড সার্চ শাকির ইসকন মন্দিরে থানার ভক্তিনগর জেলায় জলপাইগুড়ি ইংরাজি 25/5/23 তারিখে রাত্রি অনুমানিক 8টা থেকে 8টা 8:30টার মধ্যে নাগাদ পুলিশ জিপ আমাদের খাবার ভিতরে আসে এবং থেকে কয়েকজন নামে তার ভেতর যেখানে ট্রাক দাঁড় করানো থাকে সেখানে যায় এবং আমাকে ডাকে বলে যে তাদের সাহায্য করতে আমরা সঙ্গে ধাবার কাজ করে আমার দুজন রাজি হই তারপর
These are witnesses to the recovery.
ইয়েস
Where is the accused?
accused they have arrested your lordships.
Correct. So what is the interrogation of the accused?
They are doing business and they have stated in the 160.
We want read that. Today you have another accused, according to you, vicariously responsible.
I think short password, madam.
Not today. Last day you were told.
But I have seen, but nothing has been mentioned that the, as per instruction of the owner, I just.
Sir, we asked you, how did
Yes,
he
sir.
get the gaja? Who told him to collect the gaja? 100 kgs of gaja has a value, right?
Yes, lordship, yes, lordship.
So who gives him money to collect it? Who asks him to collect it?
Lordship.
It doesn't drop from
Yes,
heaven.
lordship. I agree with lordship. Just
Yeah.
one day application, lordship. Can you the question like this?
The poor driver gets, the owner is cheap. Ah.
Yes.
We are not forming any opinion against it. But we want to find out the investigation that if third persons out of greed, he contacts X, carries, you are not in the knowledge of the cover. But if that clarity does not come, then sir, a custodial interrogation of your client to get that clarity is necessary.
The accused person who was arrested, he should have clarified.
We are again saying you are in the, you claim to be in the dark. The IO does not elucidate how gaja comes into the truck.
Yes. What is the
So
source
in
for it?
our understanding, in such situation, it may be you were in the know. How do we give you anticipatory bail?
But Milord, kindly takes up the statement, Milord. I believe there is nothing against me, Milord.
We have been trying to take up this statement for the last 24 hours
Lordship, and I have
with the
intimated-
able assistance of the public prosecutors. But till now, we have not been able to penetrate it.
Then Milord, the IO really for he can explain.
Lordship, I have personally intimated that you just assist me, but he didn't turn up.
All right. Who is the officer in charge of this police station?
There is this NGP police.
NGB police station.
The inspector in charge.
Deepankar Chakraborty, IO.
Investigating officer is directed to be personally present before this court
Even I did not,
and
prison status also not. provided to me.
personally present with the court at court and explain the seized recovered gaja had how the driver had acquired the seized gaja. Full stop. Come on.
Objection.
There is no antecedent, Milord, nothing, Milord, I can.
Mr. Lawyer.
I understand your anxiety. I understand.
Your anxiety we understand. But our problem is, in spite of your anxiety, we have to satisfy our conscience.
Definitely, Milord.
And we make it clear, we not formed any opinion against you. We are trying to help you.
Milord,
If you are in a position to be helped.
yes, Milord.
But if you are not in a position to be helped, you cannot help.
I'm so grateful.
Next. Our anxiety ज़्यादा है. Anxiety.
18.
After the steps.
Parachi, the man possibly.
Am I audible, my lord?
Yes, you are.
My lord, the 20B, my lord, the section is 20B2C, 25 and 29 of the NDPS Act, my lord. The recovery has not been done from me. One is this, my lord. The other is this, my lord. On the basis of the co-accused statement, my lord.
Lordship, not only that, Lordship. His involvement, Lordship, will find another accused, Pinky Shotgun, and these persons staying in the hotel.
Pinky Halda.
Pinky Haldar Lordships and another Sarkar Lordship, the owner of the Artiga car, your Lordships. Both are arrested, but he was at the hotel at the time of incident. Lordships, IO is present before.
All right, we have followed it, Her name is appearing in the hotel register.
Registered your Lordships.
Petitioner contends his complicity transpires from statement of co-accused, no narcotics was recovered from his position. The recovery was from the hotel room.
Lordship,
Not from a vehicle,
was in a hotel at the time of incident. They are
not from-
accompanied by the accused Lordships.
not my lord, from the vehicles itself.
Sir,
Lordship can
one
be seen.
second,
My
one
lord, my lord,
second.
my lord.
We'll come back to you.
My-
This recovery was from where?
From outside Lordships. And the petitioner was staying with the Pinky Haldar Lordships.
One like 1 second.
Certainly space 6, your Lordship.
Vehicle was inside in the hotel compound. Upon was the driver of the vehicle.
Yes,
right?
Artiga Lordships. Owner of the vehicle also.
And Pinky was also in the vehicle,
Yes, yes, Lordship.
or Pinky was in the hotel.
Lordship, the name registered, both name is Lordship, I understand.
Yes. Contents, no narcotic was recovered from his possession. His complicity transpired from statement of co-accused before police, which is inadmissible in law. Accordingly, he prays for bail. Learned lawyer for the state content petitioner is petitioner conspired with co-accused Pinky Haldar and Shopon Sarkar, bracket owner of the vehicle, to transport narcotics. He and Pinky resided in the hotel, in a hotel at Kuch Bihar. Pinky accompanied Shortford and lifted a narcotic consignment and came to the hotel. At that time, police raided and apprehended the co-accused, Pinky and Shopon. Petitioner fled from the hotel. We have considered the materials on record. Recover materials from record. prosecution alleges that petitioner had entered into conspiracy with Pinky Haldar and Shopon Sarkar to transport narcotics. Petitioner and Pinky Haldar resided in a hotel at Kuch Bihar. Pinky accompanied Shopon to collect the narcotic consignment and came to the hotel. At that time, police raided and recovered narcotics from the hotel. They arrested Pinky and Shopon. Statement or Pinky and Shopon. It is contended petitioner ran away from the hotel. Involvement of the petitioner is not on the statement of co-accused Pinky and Shopon alone. Hotel registers corroborate the prosecution case that petitioner was present in the hotel with Pinky Haldar, along with Pinky Haldar, footstep. In light of the aforesaid materials on record and restrictions under 37 of NDPS Act, we are not inclined to grant any such.
Obliged, your lordship, highly obliged.
Next.
But in this matter, I am appearing for the petitioner. This is an application for anticipatory bail under section 120B, 409, 465, 468, 471, and 419 of the Indian Penal Code. But what has happened, it appears that fraud has been practiced by the bank manager of Uttar Bongo Kshetriya Gramin Bank. And 110 numbers of loan was sanctioned, out of which 53 numbers loan was granted with fake documents. Although petitioner obtained loan with genuine document, which is page 10 annexure A. Petitioner got rupees 1 lakh rupees, but although sanction was granted 1,90,000. And balance amount of rupees 90,000 was not paid, and it was told that it shall be transferred in my account. But practically fraud has been practiced upon the petitioner, for which complaint has been lodged. But page 18, kindly looked into, Lord. Page 18, Lord, kindly look into.
The branch manager Pintu Bhadro actually formed a racket, and 110 Kishan credit card loans were issued to sanctioned and disbursed.
So
those
this person is set up as one of the farmers. And the money is divided between the bank manager and this person, 1,90,000.
Lordship, one document, which speak in volume.
Yes.
That this person also changed his father's name. Fraudulent, he has also given a fraudulent QIC. Page 110. What it is written, ECI bearing number such and such in the name of another Kaushik Burman, whose father name is Bhavani Burman, instead of Kamalakho Burman.
He is saying his father's name is Bhavani Burman.
But here it says instead of Kamalakho Burman. Kamalakho Burman is actually his father's name.
No, in the petition also is listed.
Yes, in the petition he has said Bhavani Burman. But this document is saying that his father's name is Kamalakho Burman.
Okay.
That means there are some discrepancies in the KYC.
Even if the KYC father's name is wrong, will that be a material misrepresentation? Will that impact the grant of the loan?
Actually,
is there any person apart from the petitioner, Bhavani Burman, son of Kamalakho Burman, who is entitled to the loan, and the petitioner impersonates as Bhavani Burman?
Lordship, the allegation is the KYC were changed.
Correct, but this KYC, the picture is same of that of the petitioner, isn't it?
Yes.
Then how can you say that this is a fraudulent loan?
The involvement of the petitioner is only up to this extent.
Right.
Only up to this extent.
Then in his account, how much is credited? How much is credited to the petitioner?
1 lakh.
1 lakh.
1 lakh.
But he had given a loan of
1 lakh
90,000.
90.
And he says that he was made to
I
sign
already issued a check.
blank documents.
And
Blood. Another thing, blood, page 20, blood. I have issued a check of rupees 1 lakh to refund the amount.
okay, he has refunded them.
Huh?
He has refunded them.
He has demanded 1 lakh.
1 lakh.
But the amount which was drawn on his name is 1,90,000.
1,90,000.
Then what he has refunded?
He has refunded only 1 lakh.
How this 90,000 was withdrawn? He is taking that. He was aware of it. He was aware. His name was being used to withdraw the amount. He got part 1 lakh and the manager took away with 90,000. When did he refund 1 lakh?
On 12th December 2024.
So, was he otherwise entitled for the loan?
Yes, his dad is silent about that.
Why is case daddy silent about that? If this is a fake KYC, the KYC only speaks of an incorrect description of the father's.
Others.
Is he otherwise entitled to Kishan credit loan?
Actually, Kishan credit card loan account. Actually, the allegation is that after verification, it has been found that the account holder could not reside to the recorded address also.
So we want to know about the credentials of this person. Ask the IO to be present. IO is directed to be present and directed to submit, be present and submit report with regard to the authenticity of the credential of the petitioner who is alleged to have received loan under Kishan Credit Card Scheme.
Much of this.
You understand? He is a part of the entire racket.
Part of that.
He does not reside at his address. His father's name is
Father's name is different.
the name is created, same name.
Same name.
He may not be at all entitled to that loan amount. Next.
20.
Fact of this cases, your marriage discussion between two families were not failed. After which period, the mother cannot happen to lodge a complaint against him.
Yes, but in the meantime, something very drastic happened. That is why the mother lodged a complaint.
So far
The
as
drastic act is the mother's daughter committed suicide.
yes,
So you go to custody. Yes.
I am the mother and the sister. I am
Then
the
you may have made the demand for dowry.
kindly sees the complaint as well as the statement. I am only possessed of the complaint. The complaint is completely silent so far as our role is concerned.
जब 28/5/2024 में मैं मेरा हस्बैंड अनिल यादव के घर समस्तीपुर में गए.
Yes.
अनिल यादव ओमचंद के जीजा. तब ओमचंद नहीं था पर मुन्नी देवी, अर्चना देवी, अनिल यादव हम लोगों को कहा 40 लाख देने, 40 लाख कटा जमीन अगर हम दहेज में नहीं देंगे ओमचंद की शादी के साथ नहीं होगी.
Page 10 of the petition below. Finally comes to page 10 of my application.
Yes.
Now the first 3 lines. It says, my lord, Archana Kumari Om Chandra at page 10 of my application.
That is FIR is at page number 2, Lordship.
So what are you trying to say?
Lord Archana, this is the role of the present petitioner. अर्चना कुमारी एवं लड़के की मां मुन्नी देवी से मिली जानकारी के अनुसार हमें यह पता चला कि लड़के वाले तब तक इस रिश्ते से आगे नहीं बढ़ेंगे जब तक इनकी मांग पूरी ना हो। ओमचंद्र का कहना था इन्हें दहेज में नगद 40 लाख चाहिए। Will the prospective groom and the jija and the brother-in-law of the prospective groom are the
petitioner submit that
So kindly
they
consider
are the
the
mother and the Munni is mother and Archana is sister-in-law. Who is Archana?
Archana is the sister.
Sister of sister-in-law.
They were not married. The marriage discussions failed.
Sister of the boy. Petitioner contends that petitioners are the mother and sister of the principal accused, Om Yadav. Marriage between Om and the victim girl had been fixed. Due to circumstances beyond control, marriage did not fructify, victim committed suicide, and petitioners had been falsely roped in. They pray for anticipatory bail. Now, the lawyer for the state opposed the prayer. We have considered the materials on record, including statement of the mother. Whose statement? Statement of the mother of the deceased girl. In her statement, the mother contended that petitioners, being the mother and sister of the prospective bridegroom, told her unless dowry would be paid, the marriage would not go ahead. Out of agony, victim committed suicide. In light of the aforesaid incriminating materials, we do not consider it prudent to grant anticipatory bail. Next to
21 million I see it's not just because misconception when filed this application.
What is the misconception?
That the petitioner is in custody, however, will not be come in anticipatory bail.
Well, actually, the petitioner was arrested on 29th June.
All right.
Before that, they have filed the petition. Affirmation was done on 11th of December. And they have served the copy on us on 8th of January. They kept
All
the petition
right.
with
The petitioner is in custody. Application is dismissed as informed. Next.
22. Lord, in 22, I must candidly submit and take this small chance. Lord, this is the second anticipatory bail application. The first was rejected by your
Application for anticipatory bail
In the meantime,
earlier, there is no change in circumstance.
Lord, a co-accused has been granted jail.
Bail, co-accused has been granted regular bail. It is tried. Principles for grant of regular bail do not stand on the same footing with that of pre-arrest bail. It is under such circumstances, we are not inclined to grant anticipatory bail. We consider the prayer for anticipatory bail. Next.
23.
All these 58 to you have already seen the judgment of the Supreme Court. So be lucky you got that. Mr. 634. How many times you will apply for anticipatory?
Twice, my lord.
Not applied, it was not. Then
This is the last and final application.
last and final application.
I was not there.
So you were there, not there, doesn't matter.
Yes, ma'am. But I didn't do it. No, may I?
There are two accused persons in this matter. It's 306 matter. Two accused persons are there. One is Ramadev Haldar, the current petitioner, and another is Nilanjan Kumar. Nilanjan Kumar is already on anticipatory bail. Now the status is that Nilanjan Kumar is the fiance of the deceased, and I'm just a male friend of the deceased. Now, kindly, may I take your lordship to paragraph to page 2 of the FIR? Kindly come. The basis of my implication, my lord, is a suicide note, lordship. Now, kindly come to the page number 2 of the FIR, lordship. The first paragraph, page number 16 of the petition, lordship. First paragraph, my lord. I called my relatives, and subsequently, we also found that a suicide note written in a diary which was lying in the iron table in the room in which she was found. Later, when we realized, we found that the note was written in Hindi and the handwriting was not of my daughter. Moreover, my daughter has read in Nepali medium school and she cannot write Hindi as it is written in the said alleged note. Thereafter, the next para, the CCTV, the Nilanjan was found several times entering into the building on the same day at about the time of the incident. My lord, I was not there. My lord, Nilanjan used to taunt Nilanjan was jealous about our friendship, lordship, and ultimately several times he abused the victim on this particular issue concerning relating to our friendship. He used to taunt her. And ultimately, lordship, the Nilanjan has been granted anticipatory bail by this court. It is the order. Yeah. Last year, January, madam. 29th January 2024, Nilanjan has been granted bail, madam. Anticipatory. Anticipatory bail, madam. And I was posted in a high world. I am a lieutenant colonel in Indian Army. Right now, posted in Jammu and Kashmir. June, madam, I was here, posted here in Mangalore, Chile.
Right, what is the involvement? Malas. Kindly see statement of the security guard of the building, flat.
I had a good friendship with her. He says me, and they admit to the FIR also, and I do admit.
In the absence of the.
In the absence of the
She was not married. She was not married, just a fiancé.
Wow.
This person was there in the.
Yes. Then we have page 33. Page 30. Especially 30. Page 30.
Kindly see page 21. Page 21, madam. The medical report of the apostolic document, madam. Kindly see the name of the guardian.
Name is appearing as the guardian. Doesn't mean that he was involved. It's pretty long. It happened in March 2023, my lord. She committed.
Kindly see page 66.
July 2020.
66 is the, my lord, the suicide note. And one thing, my lord, the letters of Nepali language and Hindi are same, my lord. Letters are same. Just pronunciation is different. Nepali and Hindi. Kindly see the page 66,
Something to her.
suicide note.
Is the suicide note any handwriting expert?
No, man.
What are you here? The suicide note, if you were later Hindi, suicide note in Hindi, suicide note in Nepali, who is lodging the FIR?
Mother.
Mother. So is mother under the control of Ranadeep Halta?
Yes.
Presently,
Yes. What is the submission? Mother.
Huh? The mother, the FIR of the mother
yes.
is, I doubt whether this is the suicide note of my daughter,
Yes.
right?
This is the
What is the investigation on this? What is the investigator's view on it?
IO is present. I talked with IO yesterday night.
So,
Charge sheet submit on already submitted.
so what is the charge sheet's version? Is this the genuine document? Mother says this is not my daughter's suicide. Huh? Mother says this is not my daughter's suicide note. What does your IO say? There is some difference between honesty and convenience. The duty of an investigator is to unravel truth, even if it is unpalatable, and not to utilize his powers to have a bidding game.
Lieutenant Colonel in Army, Indian Army.
Correct. So it is a better bidding game. Tell your investigating officer, will be suspended.
He is present.
No, he is present. He is present. You are present. You are headed by your public prosecutor who is present. But truth is not present. You are least bothered about the lieutenant colonel. We are bothered about the truth. What's your stance when you file a charge sheet? Charge sheet is very easy. Just submit a charge sheet. What's your stance? What are you going to prove? Are you going to the court and prove through your prosecutors, that is both of you, are both of you going to prove that yes, this is the woman's suicide note? Yes or no?
No.
First,
No.
no. Then what is the connection with Ronald? If there is no suicide note, the suicide note implicates Ronald.
Yes.
Right?
Yes.
You are disowning the suicide. It's not a case of murder that the person last seen together.
No.
It's a case of suicide. So, ask your investigating officer to investigate this properly. We're keeping on Monday. And we want an English translation of the suicide note, whatever it is.
Yes.
you send the suicide note with admitted handwritings.
Not then yet.
Why not send?
Yes, but I'm already.
Why not send, Mr.
When I saw the.
Please understand, everything hinges on the suicide note.
Only depends on suicide note.
Then if you rely on the suicide note as genuine, you have to also explain as the prosecutor why the mother doubted the suicide note in the first place.
I cannot say in open court, my lord.
You have to say it in open court, sir.
I talked with the IO yesterday, my lord.
I have
I
instructed,
talked
my lord.
with the IO yesterday night, your lordship. He told that the petitioner and the mother of defective complainant are collusion.
Already, if they are in collusion, then circumstantial evidence will prove and replace that. If you have information that petitioner has approached the de facto complainant, this is vital evidence to reject his anticipatory bail.
And my petitioner also filed in the application and affirmed the affidavit personally.
So what? What is that great? How that becomes?
Still absolving.
No, he is in active service of Indian Army, my lord.
He is a member of the left. He is a lieutenant colonel in the Indian Army. He would give better evidence than you and me as to presence.
Yes.
Please be better equipped as prosecutors. Your performances are sometimes not facilitators for administration of justice. You must know what is your case. You people don't know what is your case. You don't know what is your strong points, what is your weak points. Someone affirming an affidavit is not a strong point. But someone influencing a complainant to make a false statement in the FIR itself is a circumstance militating not only for his rejection of anticipatory bail, but conduct to show his culpability.
Yes.
Yes to is very emphatic, but the behavior and the way you assist is not so emphatic. That's why we are saying you don't know what is your strong point. You don't know what is your weak point. And then comes the layers of powerful accused, moneyed accused, and their influences on various layers of criminal justice. We want a better focus in the investigation before we take up this matter. Particular, the nub of this case is this suicide note. If it is a false suicide note, was it prepared by his hand? He was present there.
No, Nilanjan was present there, madam.
No.
When it was.
He was.
No.
Sir, if the suicide note was generated in her presence, you were present there. You were present soon before she committed suicide. No.
CCTV footage.
Unfortunately, yes. Your vehicle was seen standing.
Yes.
You were seen entering. You came out half an hour later, the girl is recovered as the person who has committed suicide. And a purported note is found. Now, is the purported note generated by whom? Who has generated it? Niranjan may have generated it.
Yes.
Mother does not think so. They would try to portray, they are portraying now that it is you who are prevailing upon the mother to say this note is not genuine. Now, if that is having modicum of truth, the first and foremost is to collect admitted handwritings and the note and send it for a handwriting expert's verification. If it comes out in the handwriting of the deceased, then it becomes very dangerous for you. That you say, mother says, and they say that you had prevailed over the mother to make this statement. We don't know. Okay. So we want that exercise to be done. And then we will take the call on answering. We keep it on Monday. Guys, please do the next. Yes, next matter.
24 or 14A and 14C of the corner set. Technically, I'm an Indian. I was
Yesterday, another point is.
This is Toto or
Yes.
he is also, all Toto drivers will go to jail.
it's submitted.
All Toto drivers
I was
carrying
implicated-
Bangladeshis will go to
I
jail.
was implicated on the basis of statement.
All right.
Yesterday,
Statement.
who accused
Who accused
Deputation
statement?
was rejected.
Why to
We have
statement?
rejected co-accused.
Yesterday.
Right.
Yes.
We have considered the materials of record. Petitioner was all very
But that is
another case.
Yes.
Is he the owner of the Toto?
No, my lord, I am not the owner. As per the FR, 3 Bangladeshi people who has been arrested, and from the statement, 2 persons are named, one Ujjwal Bhagat and this person.
All right. Petitioner contest.
Charges are written.
Why did you submit charge sheet without his complicity? Without exploring it, he was not available. Why did you submit charge sheet? He is the broker who is bringing in Bangladeshis.
Or will see, Lordship.
Huh?
In the town, Lordship.
That is why we are saying, so you did not investigate the tout and why did you submit charge sheet? Surrender. Sir, we are not concerned. Petitioner is, we have considered petitioner contents that his complicity was, has transpired from statement of co-accused. Accordingly, co-accused that he was ferrying Bangladeshis into, illegally ferrying Bangladeshis into India. He prays for admissibility bail and a lawyer for the state opposed the prayer. We have considered the materials on record. Prosecution case is that the petition had was illegally ferrying Bangladeshis into India. He was not available during investigation. Further investigation with regard to his role in the crime which has impact on national security is essential. Accordingly, we are not inclined to grant admissibility. Next.
25.
It's a prayer for anticipated.
Very good.
And it relates to CVPS case number 662 of 2023 dated 18/5/23, and the sections are 406, 120 of IPC and section 3(4) of the West Bengal gambling and price.
So what are you doing for 1 year running around? Petitioner
I'm not in
Lordships.
I'm not naming.
He's enjoying, he's the main kingpin, all the money collected and transferred his account, those statement of account is here, your lordship.
Two
He's the-
persons were arrested
he's the
and
main-
only 6,000, the FIR says only an amount of 6,000 and 6,700. You are playing gambling during 23 IPL.
Now 25 IPL will
It's
start.
coming.
So you go into custody so that someone starts his own business. You were Siliguri. Siliguri board is controlled by you.
No, I'm reside in Bakura.
From Bakura you are.
This is allegation made, the statement made by one of the accused persons in full
How the money.
How the money trail shows that it flows into your account.
Yes, lordship.
Now you deal in cryptocurrency. All right. This is the past. No money like this.
3 and 4 is not applicable. This is 3 and 4 is not applicable. This is 3 and 4 of this West Bengal Gambling and Price Competition Act is not applicable.
Why?
I was not present. I was not present, and moreover, 3 and 4. Let me allow.
There cannot be any 120B in 3 and 4. There cannot be any 120.
4 relates to house. You are being the owner and occupier and use of a house, room, rent, one, now.
Very good. You cannot be a conspirator to the gambling. Petitioner contends that he had no role to play in the gambling operation pertaining to 2023 IPL matches. ingredients of offence under section 3 and 4 of West Bengal Gamblings Act do not apply. He prays for do not apply to the petitioner. He prays for anticipatory bail. Learned lawyer for the state submit petitioner is the kingpin of the gambling syndicate. Monies collected in the course of gambling during 2023 IPL cricket matches had been credited to his account. He had absconded for a protracted time.
It's not absconded.
No, he had not absconded. Warrant is pending from which date to which date? We have considered the materials on record. Gambling activity, petitioner is involved in, it is alleged petitioner is involved in gambling.
I'm not pressing it.
No, we are rejecting it. And we will get a report from the IO with regard to your apprehension. Don't worry about this. Be very rest assured, if you come here, we will be as much eager to give you assistance and protection, as much aggressive in ensuring administration of justice. All right. This is not a playfield. Criminal justice system is not a playfield to earn for lawyers and police personnel.
This gentleman,
That gentleman has to surrender or will be forthwith arrested. Petitioner is prosecution case involves.
And he is from Bakura.
We have heard you, sir. Petitioner's prosecution case involves illegal gambling in connection with 2023 IPL cricket matches. Materials collected during investigation are clearly in disclosure shows the monies collected during gambling were routed to bank accounts maintained by the petitioner. This incriminating material implicates the petitioner in the alleged gambling activity. He was not available during investigation, and warrant of arrest has been issued. He has not been arrested as yet. Under such circumstances, in view of the nature of crime involving organized criminal activity, namely gambling, and his abscondence, we are of the view this is not a fit case to guardian and rejected. Next. Twenty-six. Schedule first, this is not maintained. We are taking a view, it is not maintainable. All right. You have sold land belonging to scheduled tribes.
No, Doctor. This is not the allegation.
Yes.
No, Doctor.
All right, we'll reject it. Both on maintainability.
Let me find my case.
Don't worry. We'll make your case.
Now, Lordship, page number 14 is the FIR.
Yes.
As per the FIR, the dispute created in 2023. Now they have lost the FIR. The petitioner here is a doctor. Allegation is that I have made a wall in a land. Now we have filed one application before the Learned Civil Judge Senior Division. The order is in page number 16. Civil Judge has protected us against this defect of operation. Page 16. Page 15.
The victim has to be notified.
Yes, Lordship, it can be 15 capitals.
Add the defect to complainant victim as a party. Officer in charge shall notify the victim with regard to a right copy of the application. Officer in charge shall supply a copy of give a copy of the application. Add victim as a party. Copy of the application be served upon the victim. through registered speed post as well as through the officer in charge of the police station concerned. Victim de facto complaint victim shall be notified with regard to her right to participate in the proceeding and right to legal representation to High Court Legal Services Committee. Matter will appear on. Next.
Number 27.
My lord, 27, my lord, I appear on behalf of the petitioner. My lord, I am appearing virtually, my lord. My lord, the non-available sections, my lord, are 316.2 and 303.2 of the, my lord, Bharatiya Nyaya Sanhita, my lord, which correspond to, my lord, 406 and 379 of, my lord, the Indian Penal Code. My lord, both are within 7 years, my lord, and covered by Ornesh Kumar. My lord, subject to correction, my lord, no notice under 35(3) or 41A has been issued. My lord, for your lordship's convenience, my lord, we have prepared a short, my lord, list of dates. It's just one page, my lord. My learned friend, my lord, Miss Acharya will hand it up to your lordships. My lord, the background is, my lord, the de facto complainant, my lord, since 1972, used to run, my lord, a petrol pump, my lord, on a 24 kata land, which he had obtained by lease, my lord, from one Moti Chand Mukhia. Now, my lord, the lease was for 21 years, but during pendency of that lease, my lord, in 1984, my lord, the petitioner and my lord, his sister, my lord, we purchased the land, my lord, along with the lessee. Now, my lord, when the lease was to expire, my lord, in 1993, myself and my sister, my lord, both of us, my lord, we wrote, my lord, to the de facto complainant to vacate. But, my lord, what happened is, my lord, in 2001, my lord, 2 criminal cases were initiated against the de facto complainant, my lord, for violation of the Essential Commodities Act. And from that point of time, my lord, from 2001, my lord, the petrol pump was closed. In fact, my lord, at page 57 and 58, your lordships will find, my lord, that Indian Oil, my lord, had terminated, my lord, his license, his dealership, and also, my lord, Indian Oil had surrendered the explosives license of the petrol pump. Now, my lord, thereafter, in, my lord, 2004, my lord, partition suit was instituted by and between me and my sister. My lord, the partition was effectuated, my lord. The final decree, my lord, was passed in 2009. Now, my lord, in 2024, my lord, after, my lord, the de facto apparently has been acquitted in the 2001 EC Act case, my lord, he has sprung into action. And, my lord, he is trying to, my lord, to take possession, my lord, of the lands, which, my lord, is partitioned. One half belongs to my sister, Moina Gop, and the other part belongs to me. And, my lord, the subject matter of theft, which they have alleged in this FIR is, my lord, 3 underground tanks of, my lord, of the petrol pump, which, my lord, has not been used from 2001 onwards. In fact, my lord, he has initiated another criminal case inter alia, my lord, which your lordship will find, my lord, at page 67. That he has done against my sister and her son. And now that was done on 10th of August. And thereafter, my lord, this case has been started.
Registered pursuant to directions given by an honorable single judge in a writ proceeding, that you have illegally entered possession and removed articles from the land of the de facto complainant.
My lord, is my lord's referring to the order at page 59?
Yes.
My lord, that in that writ petition, my lord, I was the petitioner. At page 59, I was the petitioner before the honorable single judge in the jurisdiction, my lord, and
Yes.
my portion was, my lord, demolished, in respect of which, my lord Justice Ghosh had passed that order, my lord.
What is your contention about that demolition?
My lord, what happened is the de facto complainant came along with police.
The problem is de facto complainant has a lease, correct? Even if the license to carry on the petrol pump business gets terminated, the lease with your predecessor, which you are now presently the lessor, does not get terminated until and unless you have terminated and taken possession.
My lord, the lease subject to correction, my lord, was for 21 years, which, my lord, at page 20 in the FIR itself.
1 years, when does it's already expired?
1993 it expired.
It expired.
The lease commenced in 1972, ended in 1993.
They are holding over in the lease property, right?
They are not, my lord. From 2001, they had stopped operating. They were nowhere.
The
It was
question
sailed by the IOC.
Huh?
It was sailed by the IOC. For adulteration, there was a case under 7 of the
Right.
IC Act, my lord. And
Against the
after the
defective.
court order, he was acquitted from the case, and the court passed an order to return all his goods. And when he went to the property and started the business, so when he went to the property, he found that 2 tankers are missing, underground tankers. So those after that, another specific case has been started. Now, when they brought this property, this petitioner along with his sister, it was an encumbered property. It was already the list is what in existence. This is the deed. It is written in the deed that the seller has leased the
If it
property.
had been sold, if it had been sealed by IOC,
My lord.
how would you say that these petitioners, who are the lessors,
My lord.
were in possession of the property?
They were not in possession of
Then,
the property.
if they are not in possession, then who pilfered? Where is the statement materials to say that these petitioners had pilfered
That
and
too
sold?
already a case is been started.
Case is one thing,
Line up.
and saying that they had pilfered.
My lord.
We
No,
say
no. Fact is that, my lord, one Moti Chand India, he was the owner of the property.
that
In
means
his name, there was a license to carry on.
we have understood.
He has an explosive license to carry on this petroleum business. Now he
Moti Chand
surrendered
did
that
not have
license.
explosive license. Lohila had the explosive.
Lohia later, it was transferred to Lohia.
Right, Lohia had the explosive license. Carrying on business, Moti Chand was the owner. Moti Chand transferred it to the petitioners.
My lord.
Now in 2001, there's an allegation against Lohia for illegal adulteration. Property sealed.
Right.
Case started. In the meantime, petitioners are the owner.
Owner.
Lawyer gets acquitted.
My lord.
He comes to the premises and says that the underground tankers have been removed.
Not only underground tankers, the other materials are.
There is complete
My lord.
theft of whatever articles or installations were
In
there.
his absence, the possession was taken by the petitioners.
Now, where is the evidence that the possession has been
That
taken
is
by
there,
the
my lord.
petitioner?
That is the pictures, everything are there. This has been taken, it is annexed with the FIR also.
No, pictures are saying that the petitioners took possession of
Petitioners
this.
took possession and removed the tankers also.
This is JCB machine.
The tankers are there, my lord. Those has been.
This was the cause of the repetition.
My lord, the tanks were of 1972, which have not been used from 2001.
Was for 21 years, but there was no cancellation of that deed. It automatically doesn't cancel when I am in possession.
His deed is 21 years. By flux of time, the lease is gone.
But
The lessee becomes a month-to-month tenure.
Month to month.
All right.
No, that was there was a tenancy agreement, my lord. There
With
was
my
a-
sister, my lord, not with me.
There was a tenancy agreement that is in page number 44 with one of the petitioners. No.
Moina Gopi is not before your lordship, my lord.
Not petitioner, one of the sister. That is in page number 44.
She is not before your lordship. And there is a partition.
Mr. Chatterjee, in the writ petition that you filed, you
My lord.
yourself did removal of the tanks from the land.
Lordships.
You yourself directed removal of the, that was filed
My
in
lord,
2024. And then his lordship had given a direction for the Commissioner of Police to look into the grievances.
My
And
lord,
then when the grievances in the paragraph 19 of the FIR, when the police goes for handing over whatever materials are there, the two tracks are found missing.
kindly see this, my lord, vis-a-vis the own statement of the de facto complainant in this FIR at paragraph 14 at page 20.
The complainant statement in your writ petition, you say two tracks were lying in the property and they should be removed by IOC because the consent of IOC to remove the tanks are necessary. Then the tanks have evaporated.
My lord, may I make this request before your lordships, my lord? My lord, there are a number of other documents, my lord, including order sheets, my lord, including, my lord, orders passed in appeal by the division bench. My lord, may I use a supplementary affidavit and place everything on record, my lord?
What is the value of these tanks?
My lord, the value of these tanks, what I inquired yesterday, these tanks are 50 years old and unoperational from 2001. Tanks were installed sometime in 1972. 50-year-old tanks, my lord. In fact, 53-year-old tanks and unoperational since 2001. My lord, the new ones, my lord, the valuation, I think, my lord, is 1 lakh per tank or something like that. My lord, my learned friend for the state can inquire.
New ones, when the new ones were installed?
New ones were not installed. They were trying to install. What they are trying to do is, my lord, after they were doing nothing. They have not paid any rent for so many years. They were not in possession.
Who was?
Well, that's section 324, subsection 4 of the same is there. That means the property valuation is less than 2 lakh.
Yes.
What is the property of the IOC?
Contents that he's the lessor. He's one of the lessors of the property.
No, my lord, I am not one of the lessors, my lord. The original lessor was Motichand Mukhia in 1972.
No one says you are one of the lessors.
No, my lord, I have not said that in my note, my lord. The original lessor, my lord, is
1984, you purchased from Lohia, from Mukhia, right?
Lordships.
And at that time, a lease is subsisting,
Yes,
right?
yes.
So
To
don't
that
you
extent.
become a lessor?
No, my lord. No. Yes, your lordship is right, my lord. Lordships.
We should have a class, Mr. Chatterjee. A
My
law
lord,
class instead of a legal argument. Petitioners are the lessors, or one of the petitioner and his sister are the lessors of the property, having purchased the same from the erstwhile lessor, Moti Chand Mukhia. One Narayan Prasad Lohia, the de facto complainant, was the lessee. Lohia was running a petrol pump. Lohia had been granted license by Indian Oil Corporation Limited, IOCL, to run a petrol pump. In 2001, the petrol pump was sealed, alleging that Lohia had adulterated oil. The petrol pump was sealed. Criminal case was registered against him. In the meantime, the licenses of Lohia issued by IOCL and Explosives Department had been cancelled. A partition suit had been filed and the property, in the meantime, partition suit was filed and property was partitioned between the petitioner and his sister, Moina Go. In 2023, Lohia was acquitted in the earlier criminal case. Thereafter, he started lodging. He sought to. Thereafter, he tried to enter the land, the property, and recommence business. This gave rise to disputes, and petitioner approached this court in WPA 4A.
1381, my lord.
In
Page 59.
2024, seeking direction upon the IOCL authorities as well as the de facto complainant to hand over peaceful and vacant possession of the land in question. A honorable single judge of the court directed Commissioner of Police, Siliguri Commissionerate, to investigate into the matter with regard to investigate into the allegations of demolition of the structures of the property and to initiate criminal proceedings. At this stage, de facto complainant lodged criminal cases against the petitioner as well as his sister, alleging that they had illegally committed theft of underground tanks belonging to IOCL. Petitioner prays for anticipatory. Petitioner contends the allegations are out and out false and pray for anticipatory bail. Learned lawyer for state opposed the prayer. They contend petitioners had illegally entered the premises, the property, and had removed the structures, including the underground tanks. underground tanks. It is also contended underground tanks, full stop. It is also contended that the petitioners had admitted the underground tanks were in the property. It's also contended in the pleadings in the writ petition. Petitioners had admitted the tanks were in the property itself. We have considered the materials on record. De facto complainant was running a petrol pump. De facto complainant was a lessee in the property. He was running a petrol pump therein. Petitioners are the lessors. Petitioner and his sister are the lessors of the property. In 2001, the licenses, the petrol pump license was cancelled and criminal case alleging adulteration was registered against de facto complainant. Petitioners contend de facto complainant in such view of the matter, there is no material to show that de facto complainant the property was sealed by IOCL. No business was conducted by de facto complainant since 2021. In 2023, since 2001, in 2023, de facto complainant was acquitted. Thereafter, he took steps to resume to recommence the business. It in the FIR, he alleges. In the FIR, he alleges
page 20.
In the FIR, he alleges that the petitioner and his sister had illegally encroached on the land and had made constructions. Directions, Judicial Magistrate Siliguri had passed directions upon Commissioner of Police to take steps to ensure that the underground tanks in the property do not cause untoward accident. In fact, oil from the underground tanks were removed. In fact, do not cause untoward accident. In fact, petitioner also took out a writ petition directly WPA 1381 of 2024, wherein he contended that the underground tanks be removed and vacant possession be handed over to them. Full stop. A learned honorable single judge of this court directed Commissioner of Police, Siliguri Police Commissionerate to investigate into the matter and initiate criminal case in the event there is illegal removal. Full stop. Illegal removal of IOCL property. Full stop. No criminal case was registered. Commissioner of Police has not registered any FIR alleging theft by petitioner. On the other hand, de facto complainant alleges petitioner and his sister have committed theft of the underground tanks. Admittedly, underground tanks are admittedly during inquiry, during handing over of the articles in the lying in the property, underground tanks were not available. Full stop.
Handing over it was
No.
yes.
Paragraph 19 of the FIR.
19 and 20. Subsequently.
আচ্ছা during কি বললাম যেন?
During handing over of the articles lying in the property undergoing
Tanks were found in the property. Subsequently, it is alleged that the tanks have been removed. Tanks have been removed. Tanks, the said underground tanks do not belong to the de facto complainant, but IOCL Limited. No complaint has been lodged by IOCL against the petitioners alleging theft. In such view of the matter, we are of the considered view, possibility of in such alleging theft. It is the aforesaid materials give an impression that there is dispute and differences between the petitioner and his sister on one hand and the de facto complainant on the other hand. Possibility of false implication on score of prior enmity cannot be ruled out. Under such circumstances, we are of the considered view, though custodial interrogation of the petitioners may not be necessary, petitioner requires to cooperate with investigation in accordance with law. Meet investigating officer once in a week on further matters.
Deeply obliged.
We'll come back after 5 minutes.
28.
My lord, 28, I am appearing online, my lord. Am I audible to your lordships?
Very loud and clear, sir.
I'm obliged, my lord. At the very outset, my lord, I am seeking leave to withdraw.
Wait, Mr. Mojumdar, they are afraid of you.
My lord, just to withdraw, my lord. No refiling leave, no further leave. I am seeking only leave to withdraw, my lord.
Let us reject it so that you can take it to the apex court.
My lord, please, my lord, I tell you, lordship, my lord, necessary facts not mentioned, rather certain incorrect facts are mentioned, my lord. But I know your lordships, my lord, your lordships will never grant me fresh leave. So I am not requesting for that, my lord.
They won't allow us to reject, they will not press the application.
At least my learned colleague should look at me.
I know, but they are afraid of you, Mr. Mojumdar.
No, my lord.
Perhaps it was only after looking at him that.
Ah,
My lord, I don't look so dreadful, my lord.
you don't know.
Most obliged.
You dreadful, but others do. Next. Thank you.
Most obliged.
Which one? Not this one. Next.
29.
Or 498, 325, 307, 34 of the agent report. It shows the other.
Injury? You have considered the materials on record. Petitioner is the husband of the victim lady.
Page 21 is the injury.
20.
She tried to commit suicide once, Lordship, after being tortured.
The accused person granted admissibility to charge his
He had tortured the victim. As a result, she attempted to commit suicide in view of the nature of allegations. We are of the opinion petitioner, this is not a fit case to grant ransom. All difficult cases we are doing.
Great.
30.
Yes.
And for the state.
Victim.
My lord, we have served a notice through postal.
But you have not made a party, how can you serve a notice to post? But add victim as a party respondent, officer in charge of Swansea police station shall notify 1 week. And next Tuesday.
Next Tuesday.
Yes. Next. Who the number?
First of all, matter item number 3.
Last rejection was discussed for default.
That is not.
I have mentioned, but this is wrongly mentioned. I should clarify.
All right. Petitioner is in custody for over 656. There is slow progress in trial and receive of bail. A lawyer for the state opposed the prayer. We have considered the materials on record. Though some commercial quantity was recovered from petitioner and overaccused comma. There is very slow progress in the matter. He is in custody for a considerable time. No witness has been examined as yet. Under such circumstances, petitioner has made out the case for bail on the ground of delay in the trial. Bail on the ground of delay in the trial, resulting in breach of Article 21 of the Constitution. It's not better for distributions and fees. Next. Next.
31.
Yes, what is the matter?
So she analysis the order passed on 11/11/2022.
Why interim bail?
Worship, paragraph 4 of the order. Solely on the ground of and the detention of the.
How long you were in?
Lordship, I was in custody at that time for 325 days.
What is lengthy in 325 days?
Lordship, actually, 207 copies were not even supplied, charge was not paid, and.
What is the stage of this?
Lordship, next date is fixed for charge plea hearing on 2/4/25. Charge plea hearing, 2/4/25. 25, Lordship.
Why so late? Because you were on board. That
No,
was.
Lordship, I was given
Let us
the,
cancel your.
Lordship, I was given the direction whether to comply with the order or not. I have complied each and every day, Lordship.
There is no difficulty. All right. Interim bail petitioner is on interim bail. No adverse report is filed. Date has been fixed for consideration of charge in 2/4/25. There is no possibility of the trial commencing in near future. Under such circumstances, we confirm the bail of the petitioner. Petitioner's bail on same ground.
Let the report be submitted, Lordship.
Next.
Lordship, the report will be kept on record.
In item number 32, I am appearing on behalf of the de facto complainant.
The report was called for. And he has complied all the conditions of the. This is the report, madam.
All right. What is the stage of the procedure?
Evidence is going on.
Evidence stage.
All right.
My last instruction is out of 25, 15 has been examined.
How long were you in custody?
Lordship, at that time I was in.
My lord, I am for the de facto complainant.
Interim bail, petitioner was released on bail in view of prolonged detention. Interim bail. No adverse report is filed. Bail is confirmed on same terms. Next. This is that matter? Yes. One second, the passover, huh? Let us finish and we learn. Passover. Next.
24, come for the petitioner.
Yes.
This is a bail in connection with Appellate.
Very good.
I've been convicted for the offense punishment within 6 POCSO Edu section 354 and 353 of the Indian Penal Code. Since the inception, I am in custody.
Wonderful.
Only on the basis of the statement, the sole testimony of the prosecutor and his parents, the conviction was confirmed on the trial. If you lordship, can you take the page number 13 of the judgment, that is the paragraph number 32. Page number 19, paragraph number 32. Kindly see. On the basis of the opinion of the medical officer, he said there is a reddish mark on the urinary tract.
All right. Appellate confirmed that he had been convicted on the sole testimony of the victim PW2 and her parents PW1 and 3. He prays for suspension of such and lawyer for state opposed declared. He have considered the offense on record. PW3 is a minor victim. She 2 is a minor victim. She alleged she had been raped.
No, no, kindly tell me out. I have received the brief this morning only, my lord. The Waklan NP has been opted, my lord.
Monday.
Then, Wednesday.
Wednesday.
My lord, since it is a very small matter, it can be disputed. That's it. There's the activity heard on people.
PCR is not there. PCR is not there, teacher. It's not there. PCR is not there. So suspension we will hear. We'll give a direction for preparation of paper.
Wednesday.
Wednesday. You want Wednesday?
Declare.
No, next Wednesday.
Next Wednesday. Next Wednesday.
That is. 29. Next.
Imprisonment for life. We have received custody about 6 years, 3 months.
What is the evidence against?
Evidence for not. Solid
Inspector Company is sworn, my lord. The accused is father.
Boss, it says I did not.
He murdered his wife. Inspector Company mother. Brain hemorrhage, my lord.
Suffering from
Deposition of PW9, my lord. Running page.
Sir, we would like the appellant, learned counsel for appellant submits that his client was suffering from mental illness.
My lord, deposition of PW1, my lord.
Yes.
Bottom has been seized, but thereafter, my lord, doctor has been opined that he is not mental. He is PW9. PW9. PW9, my lord. Running page 12, my lord. First paragraph, my lord. PW7, my lord. PW7, page number 10, my lord. Running page number 10. Starting, my lord. Page 10, running page 10, starting. Examination find that the accused Shishu Roy was mentally sound.
Mentally ill. Due to he was unable to understand the consequences of his act. As a result, hence he placed for suspension of sentence. Learned public prosecutor opposed the prayer conference. Mental assessment of appellant's mental assessment was done by clinical psychologist PW by the medical officer PW7 as well as clinical psychologist PW8. Good stop. We have considered the materials on record. Appellant had assaulted his wife, resulting in her death. PW1, their son PW1 witnessed the incident and deposed against the appellant. During cross-examination, PW1 stated his father was suffering from mental illness. His version is not corroborated by submission of any medical prescription. On the other hand, PW 7 psychologist found that the appellant was normal. PW 8 psychologist found that the appellant was normal. PW 7 medical officer also stated that the appellant was normal and not suffering from mental illness. Under such circumstances, and as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. Reform books be prepared within 8 weeks from this at trial court.
In first cases, I had not seen my father seen my mother.
But in the chief years, this one. Next.
37.
Appellate is convicted under section 22C of the ADPS Act to undergo 10 year rigorous imprisonment. To undergo 10 years rigorous imprisonment. He is in custody for 6 months. He was in bail during the entire trial. He never misused his liberty. As per the deposition, kindly raise me out. As per the deposition of all the witnesses who were present during the search and seizure, they have deposed that the place of occurrence when the search and seizure took place was Rambi Bazar. But the gazetted officer has specifically deposed that the place of occurrence that he visited to be present for the search and seizure was Maldi Bazar. Now, Rambi Bazar and Maldi Bazar is approximately 17 kilometers apart. There is a strong possibility of a gazetted officer being tutored, and there is a violation of section 50 of the Act.
Where was the articles found?
His body was searched and his scooter was searched.
So it was found in a thermoflask.
Yes,
the thermoflask is body. Thermoflask is body. Then where is section 3?
His body was also searched.
So what?
Prior to that.
That story is gone. That judgment is gone. Thermoflask, not body, 50 goes. All right. So let us dismiss the thing. That is your only point.
No,
and Ramni Bazar and what Bazar? Huldi Bazar?
Ramni Bazar and Maldi Bazar. Both are districts.
Ramni Bazar and Maldi Bazar, signature of the gazetted officer is on the seizure list. Appellant contends that gazetted officer PW PW6 claimed that he was at Mulli Bazar, Malli Bazar, but alleged seizure was at Ramni Bazar, RAMNI, Ramni Bazar, which is at a considerable distance, which are separated by a considerable distance. This improbabilizes the recovery as well as presence of the gazetted officer. There is non-compliance of section 50 of NDPS Act. We place for suspension of sentence. Learned lawyer for state opposed the prayer. We have considered the evidence on record. Official witnesses state 300 pieces of spasmoproximon tablet was recovered from a thermoflask carried by the appellant. Recovery is from a thermoflask and not the appellant's body. There is accordingly section 50 does not get attracted in the case. Full stop. Place of recovery is Ramni Bazar, and this would appear Ramni Bazar, which is not only noted in the Ramni Bazar and not Melli Bazar. Official witnesses version is corroborated by contemporaneous document, that is seizure memorandum, which endorses the place of recovery as Ramni Bazar. Reference to Malli Bazar by the gazetted officer may be an inadvertent error which does not go to the root of the prosecution case to render it improbable in light of the aforesaid and restrictions under aforesaid facts and restrictions under 37 of NDPS Act, we are not inclined to suspend these things. Paper books within
PWD, PW6, madam, not
PW6.
PW5.
PW6 is the case. Next.
Not in this case. You are convicted for 15 years for the offense punishment of 6 of course. Now before praying for suspension of sentence, Joyce Lawson candidates and about the page number 27 of my appeal here.
9 years old girl. 9 years old.
Maybe 9 the age of the victim is 9 years. Can you see the deposition of the medical officer? That is page number 27 of my appeal. Number 27. Cross examination. The case was registered on 19/7/2029. The victim girl was examined 27/2029. That is within 24 hours. I do not find
Arjun, what we do is your 33 will take it up at 2 p.m. And from 3 p.m. we will take up the civil matters. Yes. All right. Yes. The civil matters will be taken up tomorrow. Civil matters will be taken up tomorrow. And number 4 will sit from 3. Civil matter will be taken up. All the mat order 41 tomorrow. Two to three we will finish this. Then from 3 we will clear your mat. And then we will decide. You finish it very quick, otherwise.
Managing on merit application, my father is the application for the managing, that matter can be taken from the. One matter, it is very urgent matter.
In what people, who is other side in 43?
From state, Hero Burman sir, and from respondent side, Vikramaditya Ghosh.
Please inform them. At 2 p.m. we will take it up. If it is possible, we will take it up. If they are not there, we will have to give it up. But 2 p.m. we will call it. Please inform Hero Burman and Vikram. Right? So 43 will take up and 33.
Justice Harish Tandon and another justice has ordered to keep that report in the safe custody. And on 27th of September 2024, the FIR, an order has been passed to refer the register, to register the FIR. Another, the country has been hired for an
Mr. Morgan, what is the fate of the investigation? We are getting a report today.
Yeah. That's right. The 9 accused persons whose bail bonds were signed purportedly by the appellant. And these bail bonds, according to the appellant, were not signed by the. Have you verified these signatures?
It's already, investigation has been started in September. It was registered in September 2024. And we have examined such witness and Vilcon has been already seized. Some Vilcon has been seized. That's not the report.
The bail bonds contain the signature of the surety.
Yes.
The surety is.
Earlier, it was, the report was called for by your lordship, it was stated that it does not match with the calculation. There are other reports.
It does not match.
No.
So these are not genuine signatures.
No.
Now, who signed on behalf of this?
That is investigation is going.
Who's the other seniority?
My lordship, not made, my lordship, this court order to bring all the disputed documents to, for forensics, my lordship. And that report has been come, but the report has been placed before the, in, strict custody, my lordship. We don't know what there is written, but my lordship, this court ordered to send the, signatures of respondent number 8 also, but the result that match or not, that is not, so my lordship, known up till now. My lordship here, my lordship can be submitted in Bengali, my lordship. My lordship, এই ম্যাটারে অনেকেই my lordship জড়িত আছে, কিন্তু আমরা জানি না তারা কারা এক্স্যাক্টলি। কিছু জনকে my lordship আমরা চিনতে পেরেছি, কিন্তু সেটা my lordship ইনভেস্টিগেটেড অফিসারই ভালো পারবেন ঠিকঠাক পার করতে my lordship। এর জন্য my lordship আমাদের উপরে যেভাবে টর্চার করছে my lordship, আমার একটা 13 বছরের ভাই আছে, ওনার এগেইনস্টেও ডিএসপি স্যার একটা এসসি এসটি এক্সট্রাটিসিস এর আন্ডারে একটা কেস রেজিস্টার করে, ইভেন ওখানে চার্জশিটও ফাইল করে my lordship। আমার ভাইয়ের বয়স 13, মাইনর। my lordship এইভাবে আমাদেরকে ব্ল্যাকমেল করার চেষ্টা করছে my lordship, বিভিন্ন লোক my lordship, এখানে অনেকে জড়িত my lordship, আর তারা খুব ইনফ্লুয়েন্সিয়াল। ইভেন এই ম্যাটারে যে আয়ও আছে, 1 মাস আগে আমাদেরকে একটু কল করেছিল আমার বাবাকে আর আমাকে একটু শোনার জন্য। উনি বলছেন যে এই ম্যাটারে ওনাদেরকে এখন চার্জশিট ফাইল হয়নি, ইভেন এখন পর্যন্ত ওনারা এভিডেন্স খোঁজার চেষ্টা করছেন, কিন্তু আমাকে এটা জানালো যে ওনাদের নাকি বেল হবে না যদি চার্জ ফ্রেম হয়, এর জন্য নাকি টাইম নিচ্ছেন my lordship। এই সমস্ত কথা my lordship আপিল আয়ো, এর জন্য my lordship ক্যান 3 আমি ফাইল করেছি এই কোর্টের কাছে। ম্যাটারটা my lordship যদি ডিস্ট্রিক্টের এসপির কাছে রেখে যায় my lordship কোর্টের সাথে জড়িত my lordship।
মানে বলতে হচ্ছে পয়সাকে দিয়ে তারপরে দিয়ে নানা রাত্রিবেলা ঘরের উপর ডিল ছুড়ে রাত্রিবেলা মানে
সারা বাড়ির যা জানলা কাজ আমার রোজ দিন আমার বাড়ির উপরে অ্যাটাক হয়, রাত্রি 12টা থেকে রাত্রি 3টা অবধি my lordship। আর দিনের বেলা বিভিন্ন এসসি এসটি লোকেদেরকে অত্যাচার করে, কিন্তু কিছু বলা যাবে না, পুলিশ বলে চুপ করে থাকে, না হলে কিন্তু ওই সমস্ত কেস ঠুকে দেবে my lordship। চুপ করে দরজা জানলা বন্ধ করে ঘরের মধ্যে বসে আছে my lordship। এখানে কারা খেলছে my lordship জানি না, কিন্তু আমাদের জীবন নাজেহাল করে দিচ্ছে my lordship।
Is the a report is before us?
All the reports are earlier reports of the discharge of the forensic.
We want the forensic report.
Yes, it is. It is under seal and cover.
Huh? Okay. So kind of. Going trying to find out. People can.
All the reports.
The district judge's report before us?
Yes, that's good.
The district judge's report says that he has furnished this Appellate has furnished around 3,000 bonds from 2014 to 2020. Your report only indicates 9 bonds. How many bail bonds report was taken for verification?
That is specifically the report, but subsequently they have first is security bonds.
Who is the investigating officer?
Earlier officer is now transferred to CID. Earlier investigator is.
Now, who is investigating this case?
President.
Huh?
It is done under the supervision of the SP Alipurduar.
You want the SP to come here?
No.
Yes. Who is
I don't-
investigating
I
this?
have to take instruction with his name. The prisoner.
That also you don't know.
I have just received the report. Last week he was transferred. Earlier I have.
How inspector in charge of Alipurduar police station is giving report?
So at present, Anirban Mujumdar has taken up the after. One Anirban.
Ask him to be present. Produced report, produced progress of investigation. Report of investigation submitted by Inspector in charge Alipurduar Police Station. By earlier order. Earlier order dated 27/9/2024. Superintendent of Police Alipurduar was directed to depute an officer to investigate the case. He was also directed to monitor the investigation. Strangely, notwithstanding such direction, the progress report filed before this court is signed by the inspector in charge Alipurduar Police Station and not by the Superintendent of Police concerned. It appears Superintendent of Police concerned. It appears that the investigation is not from the aforesaid position. We are of the view the Superintendent of Police has not conducted himself in terms of the order passed by this court, and the investigation is being conducted at the level of the local police station. Petitioner is present in person with his daughter. They complain that they contend as they have brought to light serious irregularities in the matter of furnishing bail bonds in the district judgeship. They are being subjected to systemic harassment. A false criminal case alleging atrocity, to.
There are several, we have submitted a report.
A number of criminal cases, false criminal cases have been registered against them. Against them.
Case and counter.
They are feeling threatened. They are feeling threatened. we have, they are feeling threatened. Gist of the grievance canvassed by appellant petitioner. Appellant gist of the grievance canvassed by the appellant is the appellant is a lawyer practicing in Alipurduar District Court. He also stands as a surety. It is his his suretyship had been cancelled. District Judge this
Since my father is not a regular practitioner, 6 long one.
District Judge cancelled his suretyship, which came to be a suretyship. Appellant contends he had not furnished bail bond. Appellant contends that his signature was forged in the bail bonds and he was unaware of the bonds furnished in his name. Contending as such, he approached the Honorable Single Bench. Honorable Single Bench directed. Honorable Single Bench declined to entertain the writ petition, which resulted in the present appeal. During hearing of the appeal, reports the earlier coordinate benches during hearing of the appeal, earlier coordinate bench directed earlier honorable coordinate bench directed district judge to submit a report with regard to the irregularities in the matter of furnishing bail bonds. Expert report was also called for to verify the allegation that the appellant's signature in the bail bond is genuine or not. FIR was directed to be registered on the complaint of the appellant. As a consequence, pursuant to these directions, district judge has submitted report. District judge has submitted report which is kept full stop. Report has also been filed by the examiner of question document, which shows that the signature in one of the bail bonds or
All the
how many bail bonds? In the bail bonds are forged. Full stop. Present taking note of the are forged. Taking note of these facts, a honorable coordinate bench directed the investigation to be conducted by a officer deputed by the superintendent of police under his direct monitoring. Unfortunately, now though the we are informed the investigation is being conducted by SI Anirban Banerjee Mojumdar is presently
It is
we are informed that the investigation was initially entrusted to Inspector Prabir Dotto, and upon his transfer is being conducted by Anirban by Inspector Anirban Banerjee. Anirban Mojumdar. Full stop. Anirban Mojumdar. Report with regard to progress of now, apart from assigning apart from deputy, the investigating officer, nothing is placed on record to show that the investigation is monitored by superintendent of police. In the report, progress report in investigation also is unclear with regard to the persons who are responsible for forging the signature or forging the appellant's signature. In this backdrop, forging the appellant's signature. In this backdrop, we direct the inspector, the investigating officer, Inspector Anirban Majumdar, to be personally present before this court and present before this court with a more elaborate report. In this backdrop, we direct the superintendent of police to look into the records of the investigation and submit a detailed report with regard to the and submit a detailed report indicating the persons indicating the following dash a number of bail bonds in which the investigating officer, number of bail bonds purportedly furnished by the appellants, number of bonds in which the appellant's signature has been forged, to persons responsible for committing the forgery, responsible for committing the forgery. The report shall be submitted personally by the inspector. Now, in order to do so, Superintendent of Police shall personally look into the report submitted before this court by the district judge concerned, as well as the examiner of question documents. He shall personally submit further report before this court. Right?
Probably they are not equipped with this report.
So they will get equipped with the reports.
One copy has been also not.
So
report has been filed directly before your.
So you do not require to go and look into the report. You do not feel it necessary to make an application saying that, sir, we want inspection of the reports. That can means.
We will file application.
What do you mean by that can? What you will apologize? You should expose yourself as one of the most recalcitrant, unwilling, unhappy agency being entrusted with such responsibilities. We can, we may, we would. What is this? When the reports were filed, you should have immediately said, sir, please give copies of these reports to us. Or as soon as the officer was deputed, he should have applied through you. We want to inspect the report of the district judge. We want to see the report of the examiner of question documents. Who stops you from doing it? Who stops you? You're stopping short of transferring the investigation. Superintendent of Police, personally, it needless to mention, the investigating agency shall be at liberty to take inspection and copies of the reports submitted before this court and kept in the safe custody of the registrar concerned. Full stop. Further, Inspector so and so shall file. Shall be personally present on the adjourned date. We want the report to be of the Superintendent of Police. He is monitoring the investigation. How does the inspecting officer unilaterally submit the report? Why it is not vetted by the Superintendent of Police? Then, are these orders passed for lip service only? We direct the officer, কোথায় থাকেন আপনারা? Huh?
I would that be right?
We direct the investigating officer as well as the officer in charge. Birpada police station.
No, Alipurduar.
Alipurduar Birpada police station.
No, Alipurduar, they are residing in Birpada more under Alipurduar.
Alipurduar police station to render necessary police assistance, police protection to the appellant and his family members. Full stop. In order to na, can 3 them.
My lordship, একটা submission করেছিল my lordship, the responses যতদিন করে হয়েছে আমার বাবা একটা আর্টিকেল করেছিল সিসিএম সাহেবের কাছে আলিপুরদুয়ারে যে রেসপন্সের যে সিকিউরিটি গুলো হয় নিশ্চয়ই কোনো ব্যাংক অ্যাকাউন্ট বা কোনো ডকুমেন্টস যেটা ভেরিফাই করতে হয় ডকুমেন্টস বা ব্যাংক অ্যাকাউন্টও আমার বাবা দেয়নি কোনো সময় সেটাও কার কিভাবে ওনারা করেছে এতকাল ধরে সেটাও আমাদের জানা নেই।
সুপারিনটেন্ডেন্ট অফ পুলিশের প্রথম দায়িত্ব এগুলি বের করা। Let the superintendent of police find out who are the persons responsible, and we want heads to roll. Otherwise, the superintendent of police's head will roll. Tell me. Huh? We are keeping this on Wednesday.
My lordship, report, my lordship.
All right. Wednesday.
My lordship, on earlier.
Are you investigating the case? You are an accused, right?
I am the.
Why this man's client is not arrested till now? The allegation is against him.
The till date period, the investigating officer had not served any notice.
You don't have to be served. We are asking for your custodial interrogation. Investigating agency shall be at liberty to undertake intense investigation, including custodial interrogation of suspects if necessary.
I am ready to cooperate.
Correct. You will cooperate in appropriate manner. Yes, now call 33. We are making it very clear. This is a polluting of the judicial process. And under our nose, we will not allow that to happen. Tell your superintendent of police, we mean business. So whoever are responsible for these false bonds must be taken into custody and subjected to custodial interrogation. Who are the persons who signed along with his signature? Bonds were furnished for an accused. Not only this man furnished bond, there may have been another bond furnished. So who is the person who is furnished the other bond? Who is the person who received the bond? Who certified the bonds?
Clearly, advocates.
Yes, so they need to be arrested. Give the names. Seek our leave if you want. We will permit their arrest. The advocate gown is not a immunity from criminal action. Nothing stops an arrest of an advocate if he indulges in criminal activity. Yes, call 33. We will immediately give you. This will be uploaded in the by the end of this.
No, and the report, copy of the report.
Huh?
Copy of this report.
Your police officer will come and take it.
Yes.
We have given the direction. We've given the direction that he will take it. We are surprised that till now you didn't feel the urgency.
So, see, it is going on the.
So, who is investigating? We are asking you to investigate forgery. Report is of the district judge, report of the expert is with the court. You don't apply to get a copy. Even investigation is of a sexual crime and a victim statement is recorded before magistrate, the first thing the police officer does is give me a copy of the statement you recorded. Mr. Bormon, the invest.
It was directly.
Huh?
Before your lordship.
Correct. So
under seal and cover.
that's wonderful. Under seal and cover is so comfortable for you. Everything is under cover, and you don't need to do anything. That is so beautiful. Let it remain under seal and cover. Let it not be uncovered. And that is the reason the topmost police officer of this district was asked to be activated by the coordinate bench. And what does he do? He only appoints an officer and forgets the rest. The second line of the order is that he should monitor the investigation. He does not even bother. The officer also doesn't bother to place the papers before the superintendent. This is the report we are sending to the High Court. This is the seriousness you attach to bail bonds being forged and filed before the magistrate court within the superintendent's jurisdiction. Tell me, should we have no control over person who posts this sort of a person as a superintendent? It is for the responsible administrative officers to take into notice these activities. But we can tell you, we have given you leave, and we want that within 24 hours you swing into action. Do whatever we want to find who are the persons responsible in furnishing fake forged bonds. Tomorrow, if accused run away, you will have no one to hold them responsible. That is the fate, right? If his client is responsible, he should be interrogated. If his client is not responsible, another thing. There is someone who is responsible. Identify and proceed. Yes, call the appeal.
Item number 33.
Yes, we have seen it. There is not much to argue. One argument you can make that the confession perhaps may be hit by section 26. Because PW4 was present in the confession. So if we ignore the confession, still then the circumstances are very clinching. PW9 was in the house, he ran out, informed PW5. Police came to the house and finds the appellant and his daughter with injuries.
Just one thing I would like to indicate what I have found from reading the entire report, but that a father's daughter and attempt to the son, but perhaps there was a gray area which needs to be.
What is the gray area? Tell us.
Whether this person is suffering from any insanity or not.
There is no plea of insanity.
That is not there.
There is no plea of insanity taken. On the other hand, evidence comes that he was practicing tantrikism.
Yes, that is there.
And see the nature of items which were recovered.
Yes.
The horn of a deer, etc., etc. So he may be undergoing tantric practices on his own children. It's a very dangerous to argue insanity. Insanity he was never taken.
PW4 is the police officer. It was posted as SI of he was posted as SI of PC at Joygaon Police Station at the time of the incident. He reports on 28 years of 2024. He received information that
He received information that
he found the daughter's body lying on the floor with him.
He also found Akash, PW9 hiding himself, hiding to protect himself. Appellate was in the room with injuries. They shifted the injured, including the appellant, to Joygaon Primary Health Center. Now, local people shifted the appellant, the injured along with the appellant to Joygaon Primary Health Center. Pratiksha, appellant's daughter Pratiksha was declared dead. His son Akash, appellant and his son Akash were referred to Alipurduar District Hospital. In his presence, the appellant wrote a confessional statement at the back on the rear of the outdoor ticket. He seized the ticket under the seizure list. He proved the seizure list. PW6 is the other police officer. PW6 was posted as officer in charge, Joygaon Police Station. He also deposed, receiving telephonic information from Panchayat member. He went to the place of occurrence. He found he found local people assembled there. He came to know appellant had assaulted his daughter and son. They had been taken to Joygaon PHC. He went to the hospital. Appellant was present in the hospital with cut-throat injury. He wrote a confessional statement in Nepali language in the outdoor ticket. PW4, the second officer, seized the statement. PW1, PW1 lodged complaint which was endorsed for investigation to PW10. PW10 to PW10. PW7 and 8 are the PW7 are the PW7 is the medical officer who was attached to Joygaon PHC. He deposed on the relevant date. He had examined Akash Dorji. Akash had suffered sharp cutting injury on throat. He his companion stated that his father had assaulted him with a sharp cutting weapon. Injury was grievous. He proved the injury report exhibit 9. Appellant's daughter was also brought to the hospital and declared dead. He examined the appellant. He also examined the appellant. He had suffered sharp cutting injury on throat. He was unable to speak. He wrote a confessional statement on the outdoor ticket. PW in his presence, he signed, PW7 signed on the statement, exhibit 5 by PW8 is the staff nurse who also deposed. Appellant made confessional statement, which was wrote confessional statement, which was seized by police. She signed on this seizure list. She was declared hostile. PW9 is the investigating, PW Pen is the investigating officer. He deposed. He examined witnesses. Appellant made confessional statement at Joygaon, wrote confessional statement at Joygaon PHC on the OPD ticket. The statement was, the ticket containing the statement was seized by PW 7, PW 7, right? PW 4.
SI.
Exhibit 6. He seized the offending weapon from the appellant's residence. He proved the seizure list, Exhibit 7/1. He collected injury report of Akash, PW9, Exhibit Akash, full stop, exhibited for the third. He seized the postmortem report. He collected the postmortem report, Exhibit 12. He collected, Akash made statement before magistrate. He collected the statement. He submitted charge sheet. Mr. Mojumdar contents, appellate contents PW9 is not an eyewitness. As Mr. Chaudhary submits, PW9 is not an eyewitness. He deposed, his father had assaulted him and he ran away. He had not seen the assault on his daughter. On the other hand, grandfather was present in another room of the house. He has not been examined. Panchayat member Nima Lama, who informed police, has also not been examined. Genesis of the prosecution case has not been examined. Genesis of the prosecution case is in doubt. Has not been examined. Nothing is placed on record to show that the injury on the appellant is a self-inflicted one. His confessional statement was made in presence of police officers, PW 4 and 7, PW 4 and 7, and is hit by section 26 of Evidence Act. Prosecution case suffers from various infirmities and is liable, and the appeal and the conviction is liable to be set aside. Mr. Learned Public Prosecutor contends PW9 is an injured witness. He is the appellant's son and was present at the place of occurrence. Appellant is a practicing tantric in an inebriated condition. He assaulted his son, who suffered cutthroat injury, and thereafter murdered his own daughter. Out of remorse, he tried to take his life. He was shifted to hospital. Appellant along with the injured children were shifted to hospital, where his daughter was declared dead. Prosecution has proved the case beyond doubt. Analysis of the evidence on record in the backdrop of the aforesaid submission show that the prosecution case primarily hinges on the injured witness PW9. Injured witness Akash Dorji, PW9. Akash is the appellant's son. He, along with his daughter, along with his sister Pratika, were sleeping with the appellant in a room. Their grandfather was in the outer room. Appellant woke up Akash and told him to see whether someone was and to see through the window whether someone had come. When Akash was looking through the window, appellant suddenly attacked him with a kukri, causing cutthroat injury. Akash rushed to the house of to the house of his neighbor Ritesh Lama. PW5 so and so was in the house. He deposed. Akash narrated the incident to them. Thereupon, local people went to the house. Local people informed police and police. PW4, police officer PW4, a police officer attached to Joygaon police station PW4 came to the spot, and they went inside the house and found the daughter lying on the floor with a cut throat injury. Appellant had also suffered injury in his throat. Full stop. Appellant, along with the two children, were taken full stop. Were taken to hospital, where Pratika was declared dead. Full stop. PW9's version unequivocally proves that appellant was the only person in the room where he and his sister Pratika had suffered cutthroat injury. Nowhere in the during the trial, appellant did not come out with a defense that an outsider had committed the crime. On the other hand, an outsider had committed the crime. In this background, non-examination of the outsider had committed the crime. In this background, in this backdrop, PW9's in this backdrop, presence of the appellant as the sole adult member in the room where Pratika had suffered fatal injury unerringly point to his guilt. Unerringly point to his guilt. Full stop. PW9's version is corroborated by a local witness PW5, as well as the appellant's sister PW1, the de facto complainant. PW4, PW4 is a police officer who came to the spot. He also found he also found Akash Dorji PW9. He also found Akash Dorji at PW9 with injury. Full stop. He came to he also found Akash. PW4 is a police officer. Okay. Who came to the spot. He went into the room and found Pratika lying with a cut throat injury. He also noted Akash Dorji was present with injury. Appellant also had an injury in his neck, in his throat. He deposed appellant and the victim. He deposed appellant and the victim, and the victims were taken to Joygaon PHC, where Pratika was declared dead. Stop. The aforesaid ocular versions, the aforesaid witnesses are corroborated by PW7 medical officer of Joygaon PHC. He proved the cutthroat injury on Akash Dorji. As well as Akash Dorji, PM report, Exhibit 12, also proves the death, also proves Pratika had died due to sharp cutting injury, which is homicidal in nature. Full stop. Homicidal in nature. Appellant's injury on the throat has also been duly explained. Has also been duly explained. Explained. has also been duly explained as a self-inflicted one. Has also been duly explained. Although has also been duly explained as a self-inflicted one. Now, it is Appellant had also suffered a cutthroat injury. Prosecution relies on his confessional statement recorded in the OPD ticket, Exhibit 9, to establish that it is a self-inflicted one. Full stop. The evidence on record, particularly that of PW 4 and 7, leave no doubt that appellant was in the control and custody of the police officers when he was taken to Joygaon PHC, where he wrote this statement. Section 26 of the Indian Evidence Act, inter alia, is a bar to admission of inter alia bars confession by an accused who is in custody of police. In such view of the matter, and given this situation, we agree with Mr. Mojumdar, Mr. Chaudhuri. The confessional statement is hit under Section 26 of the Evidence Act and inadmissible. However, no evidence, presence of a third person in the room has not been probabilized by the defense. In fact, however, unequivocal evidence of PW 9 show it was appellant and Pratikka who were inside the room when the appellant suffered cutthroat injury. Pratikka is a 6-year-old child, who had died due to a cutthroat injury. It is improbable, it is patently absurd that she could have struck her father, causing injury on him, causing his injury. In fact, no such defense that the injury on the appellant was caused by a third party was raised during trial or during trial. The clinching circumstances on record leave no doubt in my mind that the aforesaid clinching circumstances clearly established beyond doubt the fact that it was the appellant who had struck himself with the knife after having committed brutal assault on his 2 children, resulting in the death of his daughter. Finally, the weapon of offense was also recovered by the investigating officer from the appellant's house, kept hidden inside the appellant's house. Full stop. Other articles, including a deer's horn, was also recovered, which supports the prosecution case that the appellant was indulging in tantricism and had committed the crime to propitiate and had committed the crime. Full stop. Accordingly, we are of the opinion. Accordingly, the prosecution case against the appellant is proved beyond doubt. Appellant is dismissed. Conviction and sentence are approved. Appellant is dismissed.
Grateful.
Come back. Yes. Hold. What happened? What? 313 anything else?
313 is admitting.
Yes. He has admitted.
Admitted 330. 330 is admitted.
Oh. ওইখানে তাহলে ওই যে although we do not accept the confessional statement, it is relevant to note that the appellant in his examination under section 313 admitted his guilt.
Yes.
Admitted his guilt
Grateful.
as well. What? Let us see that.
No. ওটা ম্যাটার করে না, এটা বলা
Admitted his guilt.
Yes.
I assaulted my brother.
Yes.
Admitted that he had assaulted his son-in-law.
Yes.
No presence with We'll come after 10. Smile.
Should I write for PW 30? Have you prepared any note? My written notes, it's already on record already. Yeah. But PW 30 is one of the identifier of the seized jewelry for the magistrate. She is also not the biological daughter of the deceased one and stepdaughter of the deceased woman. But she says, my house is in Nepal. Kharka Bahadur Kharka was my father. Vishnu Maya was my stepmother. I was in Nepal when my parents were murdered. I found out from Facebook that my parents have been murdered. Thereafter, my uncle called over phone and informed me about the incident. I reached home in around 3 days. When I arrived, the dead bodies were already taken to Tista for last rites. I went there and participated in the last rites. Thereafter, I came to my father's house at Third Mile. The next morning, I saw the whole house was empty. Witness starts crying. There was no money or ornaments left in the house. I do not know who has done all this. Under the cross-examination, she says, not a fact. I never got any information of my parents' mother through Facebook, or my uncle did not call me. And my biological mother was Krishna Kumari. Vishnu Maya was my father's third wife. So not this comes for the first time in the report that she is the third wife of the deceased one. And Lord, she does not say anything with respect to the identification of the jewelry in her documents. Lord, PW 14, I have read the very first instance, Lord, on the basis of whose statement, Lord, the accused was implicated. Lord, I've seen 14, I will go to 15. But 15 is Rafael lecture, one friend of PW 14. He said, I am a resident of HA 13 Mile, Kalimpong. On 28th December 2021, I went to Calcutta to collect vegetables as I am a driver by profession. I went in my pickup van bearing registration number Swanson. We were watching KTV on my mobile phone while the vegetables were being loaded, and they were showing that Third Mile murder case. And at that time, my friend Damu came near us and was surprised seeing the news. He said that Krishna Pradhan has planned to steal away the property from the house of that old couple, and Damu told me that Krishna Pradhan told Damu to participate in that theft robbery. After seeing that news, Damu called Krishna Pradhan on his mobile, but Damu told me that Krishna Pradhan disconnected his phone. I saw in the news that Krishna Pradhan has committed murder. Today, Krishna Pradhan is present today in court and identified. Cross-examination, it is the fact that Calcutta market sits on Tuesday and Friday. Not a fact I was not at Calcutta on any such day, or I was not watching TV with my friend Damu. Not a fact Damu was not surprised by watching the news. Not a fact Damu did not state to me that Krishna Pradhan told him to participate in any such theft robbery. And not a fact Damu did not call Krishna Pradhan, or Krishna Pradhan did not disconnect the Next, this the recording officer, the inspector of police. It says, I am serving as, but he says he has no personal knowledge of prosecutor. But I skip to 17. 17 is also not. He is a local person. He says, I am working at Kolkata on 28th December 2021. I was at home at Nelly. On that day, I received a phone call from Roshan Chetri. He asked me to come to 3.5 miles immediately. And when I reached there, I found that police has arrived there. He called me to the house of Kharka Bahadur Kharka. As police were there, I did not enter the house. Police brought out 2 dead bodies from house, and the bodies were taken for postmortem. I heard that the dead bodies were of Kharka Bahadur Kharka and of his wife. We had a village relationship with Kharka Bahadur Kharka, and he used to call my mother aunt. In cross, he said, not a fact, nobody called me on any date, or I did not go there on any such date, or I did not see the dead body of Kharka Bahadur Kharka and his wife. Next, Milord 18 is the investigating officer while being examined for the first time. He says, presently I am serving as a sub-inspector at Riyan PS. On 28 December 2021, I was working as SI at Kalimpong case. On that day, I received charge of investigation of this case. On receiving charge of investigation, I perused the formal FIR and written complaint, visited PO, that is the house of Kharka Bahadur Kharka, prepared the rough sketch map of the PO with index. This is that rough sketch map of PO with index, prepared, written and signed by me, marked as Exhibit 30. I recorded statements of available witnesses under section 161 CRPC, collected copy thereof, paid for TI period of the seized articles, collected copy of report thereof. I conducted the inquest on the dead bodies of both the victims, that is Kharka Bahadur Kharka and Vishnu Maya Chhetri. This is the carbon copy of the inquest report of dead body of Kharka Bahadur Kharka, prepared in the same mechanical process by me, and the witnesses signed in original on carbon in my presence, marked Exhibit 4 by me. This is the carbon copy of the inquest report of the dead body of Vishnu Maya Chhetri, prepared in the same mechanical process by me, and the witnesses signed in original on carbon in my presence, marked Exhibit 5 by me. Later, I collected postmortem report of both the victims. From the PO, I seized blood samples, clotted blood, portion of mud, and dust. One old and used golden colored Samsung mobile phone, one old and used black colored Nokia mobile phone, and one black colored old and used Samsung Android mobile phone lying near the dead body of Shambhu Chhetri. That is another name of Kharka Bahadur Kharka in the presence of witnesses. This is that scissor list prepared, written and signed by me, marked Exhibit 7. I seized one brown blanket with blood stains covering both the dead bodies, one black and white colored printed old and used double winter wrapper with blood stains, one printed plastic mat with blood stains, two old and used plastic chocolate colored chair having blood stains, which were found near the dead bodies of both victims under proper scissor list. This is that scissor list prepared, written and signed by me, marked Exhibit 8. I seized one brown colored jacket and brown colored underwear with blood stains of the male victim, sealed plastic containers containing PM blood, viscera, nail scrap of victim Kharka Bahadur Kharka, one green colored t-shirt, sealed plastic container containing nail scrap of the victim Vishnu Maya Chhetri on 28 December 2021. This is that scissor list, prepared, written and signed by me, marked Exhibit 9. I seized 22 numbers of Indian currency notes of rupees 2000 denomination each and 33 numbers of 500 denomination each. One golden colored necklace looking like gold, one golden colored finger ring, another golden colored finger ring with green colored stone, and one old and used brown colored small synthetic bag with broken zip from inside the steel almirah at the bedroom of the accused Krishna Pradhan alias Tanka in presence of witnesses. This is that scissor list prepared, written and signed by me, marked Exhibit 10. On 10th of January 2022, I arrested the accused person from Lower Tashidi. I produced him before court on 11 January 2022. I prayed for police custody and my prayer for custody was allowed for 7 days. While he was in police custody, I recorded his statement and he stated that he will help police to recover the weapon and other articles if allowed. Following the statement, I took him to his house. And as shown and produced by him, I seized the currency notes and jewelry. This is that part of the statement which led to the discovery. Statement leading to the discovery, we marked Exhibit 14. On the basis of the statement, I took Krishna Pradhan alias Tanka to the bush below old abandoned school building, Little Flower School, at Lower Tashidi, Kalimpong. And there from below the bush, he brought out the iron weight kukri with wooden handle, with blood stains, and I seized it in presence of witnesses. This is the scissor list prepared, written and signed by me, marked Exhibit 11. The accused also signed in my presence. These are the currency notes that I seized on 12 January 2022 on showing of accused, reference Exhibit 10, identified at Exhibit 4. This is that gold chain, one gold ring, another gold ring with green stone that I seized from the house of the accused on his showing, reference Exhibit 10, marked Exhibit 5. I procured a certificate from Singh Jewelers, Kalimpong, to ascertain whether these 3 articles are made of gold or not. And the jeweler gave me a certificate that the chain and 2 rings are made of gold. This is that certificate issued by proprietor Singh Jewelers and collected by me in original, certificate marked Exhibit 15. Previously marked X for identification. I kept the Xerox copy of the scissor list with the jewelry and the cap that I seized as label. This is that Xerox copy of the scissor list, kept with the seized cash and jewelry, marked Y for identification. I sent the bloodstained weapons wedding apparels and blanket mat, etc. for RFSL examination on 22nd February 2022. That is not after 40 days of seizure. I received the report of RFSL on 13th September 2022 and 21st January 2023. These are those two reports of RFSL dated 1st September 2022 and 16th January 2023, marked Exhibit 16 and Exhibit 17, 2 pages respectively. These are the two serological analysis report in respect of seized articles, both dated 2nd December 2022, collected by me, marked Exhibit 18 and 19 respectively. In the report dated 2nd December 2022, in respect of blanket, khupri and khupri handle, it was found by the expert that it contains human blood of A, AB and O group. In respect of second serological report, it is found that the nail cutting, PM blood, etc. contain human blood, although the group could not be ascertained. This is that khupri that I seized on showing of accused on 12 January 2022, identified MAD Exhibit 3. I did paste a label prepared by me in presence of witness on this khupri, but it is now damaged in rust and water, completely torn, and damaged label is found on the seized khupri. This is that blood-stained blanket, plastic mat having blood stains that I seized, identified MAD Exhibit 6. These are those 3 mobile phones that I seized during investigation, identified MAD Exhibit 7. These are the plastic containers containing the biological sample of victim, identified MAD Exhibit 2. This is black and white colored printed double winter wrapper, identified MAD Exhibit 1. The seized jewelry were put for test identification parade before the witnesses, and witness Sri Vishwadip Chetri identified both the rings, and witness Srimati Bhakta Kumari Karki identified the gold necklace and one finger ring not having green stone during TIP. The TIP was held in the chamber of learned judicial magistrate. These envelopes contain the bloodstain mark of PO collected by me, collectively marked MAD Exhibit 8. These are the 2 boxes containing viscera of the 2 victims. It contains the prescription of RFSL Jalpaiguri signed by the reporting officer in original, affixed in both the containers, marked MAD Exhibit 9. These 2 contain Exhibit 1 and J as specified in report of RFSL reference Exhibit 15. I collected PM report of both the victims. After inquest, I sent the dead body to hospital for postmortem through Constable Kailash Pradhan. These are the 2 dead body challans of Shambhu Chetri alias Kharka Bahadur Kharka and Vishnu Maya Chetri, prepared, written and signed by me, marked Exhibit 6/4 and 6/5 respectively. On completion of investigation, I submitted charge sheet under section 302 IPC against accused Krishna Pradhan on 4th March 2022. Later on receiving the report of RFSL, I submitted supplementary charge sheet. The supplementary charge sheet mentions the names of the forensic experts as witnesses. The accused is present before court today and identified. Now that in cross-examination, he says, I received charge of investigation of this case on 28 December 2021 at about 9:55 hours. The reporting of the incident started with lodging of specific FIR. There was no information before lodging the FIR. It is a fact that one unnatural death case was also started side by side with the investigation of the specific allegation. I was entrusted with the charge of inquiring of the UD case also. The inquest report was prepared on 28 December 2021 at 12:35 hours and closed at 14:25 hours. During this period, both inquests were held. I have not mentioned the time taken for the 2 inquests separately. I did inquest at the PO itself. I cannot say from memory whether the door of the house where the dead body of the victims were found ajar or closed. When I reached there were some local people present there. No further complaint was lodged to me by anybody at the place of occurrence. During investigation, I recorded statement of the witness Ravi Chetri alias Ramu Chetri alias Damu Chetri. It is a fact that this witness did not state to me that he went to deliver fee to Sangeeta, whereas he says otherwise in the statement. I recorded the statement of the accused under section 161 CRPC during police custody. It is a fact that during his statement recording, Krishna Pradhan did not state specifically that he has hidden the khupri behind the bush near the Little Flower School, reference Exhibit 13, or that he has hidden the jewelry in his almirah inside his bedroom. It is a fact that such khupri, reference MAD Exhibit 3, is available in the market at Kalimpong. Not a fact I procured the khupri from other sources and falsely implicated the accused. It is a fact that I have not noted in the seizure list the number of currency notes that I have seized. it is a fact that I did not find any bill of the jewellery I seized during investigation. Not a fact the gold ornaments or the cash was not recovered from the possession of the accused person. I did not seize any call details of Ravi Chetri and accused Krishna Pradhan during investigation. I did not put any specific mark of identification or engraving on the body of any of the jewellery or on currency or on the kukri or on the blanket or on the mat. Not a fact I did not visit the clue. Not a fact I did not examine the witnesses or did not record the statement under section 161 CRPC. Not a fact I did not seize any kukri or jewellery, currency or showing of the accused. Not a fact my inquest report or death body challan were not prepared as per law. Not a fact my investigation was perfunctory. Not a fact I could not find the real offender and falsely implicated the accused. Not a fact I did not follow proper procedure during seizure or sending of the seized article to RFSL. Not a fact I submitted a false charge sheet. Not a fact I prepared all seizure lists sitting at Calcutta is false. Now, look, since he has stated that he has not collected the quantitative records, order was passed and invoking power under section 165 of the Evidence Act, and he was directed to produce the CDR. Now, on the next date, one Vishwajit Ora has been examined as PW 90. Next is second of August, the IO was examined, and 4th day of September, almost a month after. Yes.
Order was passed. There was order.
There was an order under section 165 of the Evidence Act that they have to produce the CDR. And since he has produced the CDR, this person was examined. Who came with the CDR? He is also police personnel. SI Vishwajit Ora, PW 19. He says, today I have come as per direction of SI Omchuk Lepcha, OC Riyam PS, who has sent a report including CDR of mobile number this belonging to one Ravi Chetri alias Ramu Chetri, son of Tarabir Chetri of Luledara, PS plus district Kalimpong, as per direction of court, along with certificate under section 65B of the Indian Evidence Act. This is that copy of CDR certified by the officer in charge of Special Operation Group, Kalimpong, on each page, and the certificate under section 65B Indian Evidence Act issued by the OC SOG, Kalimpong. The CDR contains call received from mobile number this by this Ravi Chetri alias Ramu Chetri on 26 December 2021 at 20:08 hours, 1:55 seconds duration, and one call out, that is from the mobile of the witness to the same number on 28 December 2021 at 13:45 hours. This is that CDR with this is marked exhibit 20. The CDR does not show to whom the mobile number this belong on 26 December 2021 and 28 December 2021. So, due to this discrepancy, they were again asked to come back with the customer application form, CA. The investigating officer was again examined 2 days later, 6th day of September, as PW 20. The IO says again that today, as per direction of court, I have brought the report issued by the inspector in charge, OC SOG Kalimpong, along with certificate issued under section 65B of the Indian Evidence Act, and all annexures like the voter ID card, Aadhaar card, customer digital KYC, showing that mobile number this belonged to witness Ravi Chetri alias Ramu Chetri, son of Tarabir Chetri of Loledara, Kalimpong, and mobile number this belonged to Krishna Pradhan alias Tanka, that is the accused of this case. This is that certificate issued by the officer in charge SOG on 5th September 2023. It was served to me in official capacity. I know his signature. Certificate marked exhibit 21. These are the annexures, all signed by the officer in charge SOG with his official seal in response to my query in compliance to the direction of the court. These are those authenticated copies supplied to me, 10 sheets marked exhibit 22 collected. So, based on this, the CDR has been taken as admissible evidence, and based on this and the other attending circumstances like the recovery, conviction was given to. Now, the CDR has been issued by the police personnel, which is improbable because it has to be issued by a concerned person from the telecom, the concerned telecom provider. That has not been done. So, if the 65B certificate goes, So the CDR also goes, and as such, no reliance will be placed on the CDR. Now, Lord, in so far as the recovery is concerned, Lord, the TIT, the test identification period, Lord, the magistrate comes before the court and says that they have come and identified the jewelries. But Lord, both the witnesses in their evidence does not adduce any substantial evidence, Lord, saying that we have identified the jewelries before the landed magistrate. Lord, this is first aspect. Second, Lord, the recovery of the offending people. Lord, the investigating officer clearly says in cross-examination that he has only said that if given chance, he will help us to recover the offending weapons. But he has not stated exactly where he has hidden it and how he has hidden it. So, Lord, this is another improbability in the case. But so far as the time of the seizure is concerned, Lord, as per the seizure list, it is seen that first, Lord, the jewelry he was taken to his house, and thereafter, Lord, thereafter from the nearby bush, the offending weapon was recovered. But Lord, the statement of the seizure witnesses says otherwise. They says that no, first they were taken to the bush and then to the house. But seizure list speaks otherwise. So, Lord, these contradictions will also cast serious doubts on the recovery of the offending weapon. Lord, even if the version of recovery of jewelries are concerned, Lord, the ownership of the jewelries has not been ascertained during the entire investigation or even during the trial. So, under such circumstances, Lord, the conviction is bad.
But then exhibit 14, the statement is also exhibited. The recovery pursuant to the statement, exhibit 14, page 62.
Yes, statement, Lord, that is there. Lord, can we see exhibit 14 once? It is page number 20. Yes, page number 20. As PW 14 is concerned, to some extent, his credibility has been impeached by the defense counsel in cross-examination, where he resides from his statement when he was confronted with the 161. He says, I did say this to the police, but the IO says, no, he never said this to me while recording his statement. So, to some extent, his credibility is impeached here.
Which one?
Lord. Lord, page number 56. Page 56, Lord, cross-examination last one. What? Lord, it says the second last question. I suggest that 26 was a Sunday. Then he says, I had to go to Joygaon to deliver thing to Sangeeta auntie. Lord, the next page, Lord, kindly see. Not a fact, I did not state to police that I went to deliver thing to Sangeeta auntie. But he says that I have stated this to police, but the IO refuses. So that is all. That's not a big issue. He was going to Joygaon, that is all. not the time of death, but from the versions of the prosecution witnesses, it cannot be conclusively say the exact time of death. PW2 says on 27th I came to know. Sorry, the PW7 says on 27th I came to know from the news that a murder has took place. But police is saying on 28th morning they received the information. But Rajengiri says from 26 onwards I am not getting water. 26, 27. When he was confronted that if you do not get water for one single day, will you not face difficulty? He says yes. But even still then, for 2 days, 26 and 27, he did not get water and he did not even take the pain of going and see what happened. So, my lord, the time of death is also under confusion and it is under doubt, my lord, that when
Time death is night of 26th.
But
As per prosecution, night of 20.
As per PW 14's statement.
No, as per prosecution, what is the prosecution trying to do? Night of 14, 26. Night of 26.
The very first occasion had asked me to address your lordship on the differences of opinion between the two honorable judges. If you will not, but since both the honorable judges have the same surname, my lord, I will be using the term honorable dissenting judge. The honorable dissenting judge has taken different view with respect to the testimony of PW 40. Lord, his lordship has observed that the discrepancies with respect to the of the statements or evidences given by PW 40 Ravi Chetri is of no little significance, and as such, those discrepancies will not create any problem or it's not fatal to the prosecution case. Furthermore, my lord, the honorable dissenting judge, in his observations, my lord, has heavily relied on the admission of the accused person in his 330, that he has admitted receiving the call. But my lord, with deepest respect, my lord, nowhere in 330, my lord, the accused has admitted receiving the call.
Where is the 330? What does he admit?
He has admitted nothing.
Lordship, in page number 81, Lordship, he has admitted that the phone number belonged to him. Lordship.
Yes, only that much. Number belongs to him.
Number belongs.
Question number 4.
Phone number belongs.
Phone number belongs.
Receiving call is that?
No.
That phone number belongs to him. That receiving call
Correct.
is-
Phone number belongs to him. If someone says a phone number belongs to me, means that amount to admission of the CDRs. You know, I don't.
My lord, page 74, question number 37.
Would you please present, give us, where are the, hey, it shows the reasoning of Justice Partha said, which persuaded his lordship to acquit your client. And Justice Shaw mentioned where his lordship had variance. Just indicate those portions of that.
No, I'm just learning.
No, like it's right.
He's helping you.
No, I'm not doing this. No, why not? I'm just learning.
Oh, you can help.
I'm unaware today. Still, I'm sitting here to learn.
You showed up, you appeared in one matter, no? Where there was this robbery and murder, where we delivered a judgment. Or Mr. Shabir Ahmed was leading.
No, it was the first deliverance of the circuit.
Right. You have the copy?
No, I have I have kept the paper book with me.
No, paper.
The order's copy, judgment copy.
Judgment.
Can I give it tomorrow?
Because Mr. Chaudhary, people believe the recovery. Then whether the recovery will be considered to be an incriminating fact against murder. That issue we have discussed in that last week. We understand your submission on the fact, even if the recovery is of ornaments, there's no identification that this is the ornament stolen.
Right.
Right. The purchase receipts have been exhibited, right?
Nothing. A lot of certificate from one jeweler saying that
That it is good, that is the different thing.
that is the only thing, but
No purchase receipts.
Nothing.
Only thing on which the stolen, the recovered items were sought to be proved as stolen property belonging to the deceased is the test parent identification.
Yes.
Which is not put to the witness.
Witnesses, yes.
Instruction. No effort was made to recall that witness to question. Yes, show us.
Yes. But page number 15 of the judgment, but I am having the sour, the sour copy of the judgment. Page 15.
No, you specify the paragraph.
Paragraph 26.
Paragraph 26. There are two more death penalties. This Mr. Wilson.
There are 3 death penalties.
No, that is two. List ready.
You have 2, I believe, 2 are ready.
Who are ready? Let us see this video.
Respect to recovery, paragraph 27. Paragraph 32.
Please, the paragraph 27 you want to.
Yes.
It's the paragraph 26. It's not paragraph 26.
26, 27.
Read out 26. What do you want to say?
26, Lordship say, at this juncture, I propose to look to the evidence of PW14, who, according to the prosecution, is a very vital witness. PW14, in his course of examination in chief, testified that he is a driver by profession and he used to drive his pickup van from California to Calcutta to carry vegetables. He further testified that on 26 December 2021, at about 8:30 p.m., the accused phoned him and expressed his intention to rob the 2 deceased person who used to reside near his house, and the accused had proposed PW14 to join him in committing such crime. PW14 declined to join him in the night. He left for Falakata and subsequent thereto he came to learn from TV news that murder of 2 persons occurred near the vicinity of the accused. He further testified that he immediately called the accused who did not receive his call. Cross-examination of PW14 seems to be very vital. Since in his cross-examination he stated in course of investigation the police did not seize his mobile phone. He further stated that Falakata Haat, a weekly market, remains open on Friday and Tuesday. And when he was given suggestion that 26 December 2021 was a Sunday, he changed his version and stated that on the same night he had go to Jaigaon, and such fact he had not stated to the IO. Next, from the cross-examination of PW15, who is also a driver of the said locality, it reveals that Falakata market remains open on Tuesday and Friday. As rightly pointed out by Mr. Choudhury, learned advocate for the appellant, that on comparative study of the entire evidence of PW14 and PW15, it would reveal that PW14 though stated that after getting call from the accused in the evening of 26 December 2021, he went to Falakata market, but in course of his cross-examination as well as in the cross-examination of PW15, it reveals that actually he went to some other place except Falakata. And therefore, admittedly, some contradictions have been elicited in the version of PW14. which definitely affects the reliability of PW40. Next, my lord, 27 is on recovery. No. 27 says, admittedly, the FIR which had been lodged in this case was an unknown FIR. However, in course of investigation, especially from the information received from PW14, the accused was apprehended. Since it is the case of the prosecution that during police custody in course of investigations, on the basis of discovery statement made by the accused, some incriminating materials, namely weapon of offense and looted ornaments and currencies, have been seized. As per showing of the accused, I propose to look to the relevant statement of the accused, which has been marked Exhibit 40. For better appreciation, the relevant portion of the statement of the accused is reproduced hereunder in verbatim. But that part is there, and I will help police to recover the weapon and other things. I will help you if you give time. At this juncture, I feel obligated to look to the relevant portion of the examination in chief of PW18 IO, who testified in the following manner. But the extract is there. While he was in police custody, I recorded his statement and he stated that he will help police to recover the weapon and other articles if allowed. Following this statement, I took him to his house and as shown and as produced by him, I seized the currency notes and jewelry. This is that part of the statement which led to the discovery. Statement leading to discovery be marked Exhibit 40. On the basis of the statement, I took Krishna Pradhan alias Tanka to the bush below old abandoned school building, Little Flower School at Lower Tashidim, Kalimpong, and therefrom below the bush he brought out the iron kukri with wooden handle with bloodstains, and I seized it in presence of witnesses. This is that scissor list prepared, written and signed by me, Exhibit 11. Next, we are 29. In order to come to a logical conclusion as to whether the aforesaid statement of the accused comes under the purview of Section 27 of the Evidence Act, and further the deposition of PW18 IO is also sufficient to prove that he seized the aforesaid materials on the basis of such discovery statement, I propose to look to the provision of Section 27 of the Evidence Act, which is introduced hereunder in verbatim. But 27 has been extracted. Next, 30. At this juncture, I also look to the reported decision of Babu Sahib Gora, Supra, where the Honorable Supreme Court, while dealing with the provision of Section 27, held this. And your extracts of Babu Sahib Gora is there. 30. Next, my lord, in 31.
Where does Babu Sahib Gora say that the disclosure statement must be recorded in the presence of seizing witnesses? This finding, paragraph 30.
Yes, Lord, that I have seen.
That is not right.
That is right. But not the exact words has to be that.
See, what he said that I will tell you, I can show you where he seized weapon and other articles are kept if you give me time. So this gives an indication that he had the knowledge and could show the investigating officer the place where they are kept. What is the discovery? Discovery is the knowledge of the accused with regard to the place where the secreted weapon, the weapon is secreted. Now, this is one that he expressed his willingness to show it. That is such a statement. And to that extent, if it is seen in light of PW 14, 3, and 12, he actually showed the place for where the investigating officer. So it is 27 comes into play in light of the recovery being made pursuant to a disclosure. If the disclosure and recovery are independent of each other, 27 does not. To some extent, you can use conduct and all, but 27 million. Here, 27 comes into. There is a disclosure that I will show you the place or I will help you to recover. And then the person goes with the police and in presence of 3 others shows the place at the police station. Because of this recovery, post the disclosure, a statement which otherwise is inadmissible becomes admissible. That is all. Now you can dispute the recovery, saying that the manner and circumstances, it is an open space, accessible for all, etc., etc. All these things are challenging the recovery. But there is a disclosure.
disclosure is leading to this. Would say place where he secreted is not disclosed. So it is not a distinction. We'll ask Mr. Laksum to make a submission on that, whether the disclosure statement will not be a disclosure statement if he says, I will take you to the place where the things are, or it should be seen how it is stated. He says that I will help you to recover, which means that I know it is a way of speaking. All right, this is recovery. 32. So recovery says is 33. Had not disclosed the places where it's kept. Right. So he's basically saying places not disclosed, it does not become a recovery statement. Not recovery statement. Not recovery statement. That is the crux. And 14 he improbabilizes because no heart. This heart thing are not really understood. Where does he say that? He says that he is going to Falakata 14. The position is saying, I drive pickup van from Kalimpong to Falakata to carry vegetables. Around the zone, this is an opening statement. Isn't it? How does his driving a vehicle from Kalimpong to Falakata have any relevance of his receiving a phone call from his?
No direct relevance. No direct relevance, but the only thing which that we are trying to impress your lordship that he is not a truthful witness because
And again, I drive so and so to carry vegetables. Krishna is a driver. He is never saying that on 26th he was driving the vehicle. He just says what is his profession. His profession is to carry vegetables from Kalimpong to Falakata in a pickup van. And then you start cross-examining him. When is the Falakata hard? You said you went to Falakata on 26th, but Falakata is, where is he saying that he went to Falakata on 26th?
but in his chief he has said no.
Oh, and I blocked, and that night I left for Falakata on work. He never said that he was carrying vegetables to the market. He just says that he carries vegetables and he went to Falakata for work. You somehow join the vegetable and market in cross-examination. See his chief. What does he say? I carry vegetables in a drive up pickup van. Right? From Kalimpong to Falakata. Very good. And then that night I also went to Falakata for work. Then you say, why heart is not on 26? How do you carry vegetables? Then he explains. Here he was going to Joygaon to give fee to Sangeeta. The work that he was done on 26th is not relating to Falakata, but he had gone to Joygaon.
This is the first time you are
And first time means what? He was never questioned on this. Was he questioned by the police on this? That what he is doing at night where he is carrying, did he say in his previous statement that I went to, I was carrying vegetables to Falakata market on that night? That you are not, you just say he didn't say he was carrying him to Shungidar. See, I carried for work, I went out at night. How does that improbable as firstly, whether he went out at night for work or not, really does not impinge on the main incriminating part of it. And it is explained. He ordinarily carries vegetable from Italian pop. He never says that he went to Falakata on that day. He says he left for Falakata on work. Now, Jaigaon is towards Falakata or another?
Different. But the thing is that we are questioning whether the accused has given him a call.
Would you not argue thereafter, or you will only intervene? Your option is two. You will intervene or you will argue later. If you choose to intervene, we will stop your right to argue subsequently. This patience is something which must be inbuilt in every lawyer. Even if your opponent is lying through the nose, you have to wait for your turn. Don't go on jumping on your, as if your seat is made of nails. Sit down. All right, we have followed you. You say that for Falakata you get for work, but then there was no scope for work because Falakata is closed on 26th. And 26th is the Sunday. Yes. But he's going to Falakata on 26th night. Isn't it? Night. Heart will be on 27th or 28th.
27th is Monday.
Correct. So he may be going to the Falakata heart on not on 26th. The heart will open on Tuesday. So maybe he's carrying the vegetables to Falakata. But he explains that he was not going to Falakata. There is a DPH. Cross-examination says that he was going to Jalpaiguri. Very good. That really does not impact his conversation. That is true. This is one thing which Justice Parthasarathi said has in his lordship's judgment impacted, right?
Yes, yes.
That is one thing. That is one important thing. And another is non-seizure of phone.
Not sure. And the CDR.
No, non-seizure of phone. That is it.
Yes.
Very good. And so what as 27 is lordship's view is place not disclosed, it's not a recovery. Then his lordship proceeds at paragraph 33, non-identification.
Yes.
Good. Paragraph 30.
Seven. What is? Blood stain could be. It does not match its blood. Then there was human blood. There was human blood. But whether it not matched. Because that had degenerated. Blood group. Not blood group of deceased. Right? Yes. This is Para 39 will not CDR part is not sure as discussed. Again, his lordship has not gone into CDR. Right. But in para 39, he is gone again on 40. But 10th line. I don't know, the admissibility is going in para 40. Yes. Then 41 of CDRs. That is paragraphs 42. One. Not by responsible governments. In charge. Charge of logging to resources. Put. 14 improbable. Recovery statement is not a recovery statement. Even recovery is, even seizure and recovery is believed. No substantive evidence that the jewelry is stolen property. And the cookery is the weapon of offense because there is no matching of the blood group. And CDRs. Yes. And 14 is this is it. Now we have to go to the honorable dissent to the judge. Para 96. My lord has spoken about the disclosure statement and the recovery, saying with the admissibility.
No, let us see what the lordship says about 14. First. Para 102. Para 102, page number 68. Lordship says about PW 14. But 6th line from the bottom of the paragraph. We want you the way you have analyzed your quitting judgment. Please analyze the convicting. I have done. It shows 6th line from the bottom, para 102. 102. Yes. Discussion. But there are minor discussions. 76 starts the discussion. Paragraph 80 is. Sir, the section 27 discussion starts from 78, 79. Not a last for 49. We are just asking you one by one. So tell us if you are looking for recovery, tell us. Yes. Yes. 96 is lordship. 96 is lordship gives observation, saying it as admissible in evidence. His lordship says the disclosure made by the appellant while in police custody had led to certain discovery, such as the place where the offending weapon was concealed and hidden, and the place where the stolen cash and ornaments were hidden is material and relevant for the purpose of section 27 of the Indian Evidence Act. It is admissible as the disclosure made by the accused to the police while he was in custody led to the discovery of the aforesaid facts, and hence that discovery is required to be read as evidence against the accused in terms of section 27 of the Act. Moreover, having regard to the fact that the disclosure led to the discovery of distinct facts, namely offending weapon and the stolen cash and ornaments, even if it may amount to confession, is admissible in evidence. Next. Next we have page number 66, para 101. Indication of the place in the disclosure statement is what she has given as blue. 101. Very good.
Paragraph 101. Yes. We have 96 and 101. Let us say that the jewelry also stands to recovery of jewelry, but has not referred to the witnesses' evidence in PW and PW 13.
So relied on the TI period.
Yes, only of the TI period. PW 2 Ma'am. PW 14's testimony. The observation is in 102 tab.
20 and this SOG was examined in the 2020. 1920. Opportunity cross-examination was given.
No.
How can that be evident?
But since 165 was invoked, Lord,
Mr. Counsel.
Lord, we prayed for it orally. We have not highly
No, the oral court, the judge has to give opportunity to cross-examine. How can that be evidence if it is not an opportunity of cross-examination? If that witness is not examined under 139, what are the cases where cross-examination need not be? A person who produces a document need not be cross-examined, isn't it? But 139 is not a person who is producing a document. He was proven such a relevant fact.
Yes.
How can the judge proceed to depose record evidence? We have to ask Mr. Lakshman this. How can that amount to evidence? Is he a witness under 139? Where you can your old CR criminal lecturer is there? One 44 of the bill. This witness who came as 19 and 20, was the judge posing questions under 165? Or the witness was examined in exercise of powers under 311 CRPC?
165.
160. My God. Was he a witness for any party?
20 was a witness. 20 was a witness. It was the IO.
19 was a witness.
19 was not.
Then 19 without cross-examination. Under what provision was the judge summoning 19? Was the witness summoned by the judge? Then who examined 19? If he was not examined as a prosecution witness, then you have a right to cross-examine. If he is examined as a prosecution witness and some question is put by the judge, then you have to seek leave. Here, the judge did not summon the witness under 311. He appeared as a prosecution witness. Then the judge should have given an opportunity to cross-examine that witness. Where is the scope for why cross-examination will be with the leave of the court? We don't understand this 165. 165 applies when a party brings a witness. And in the course of the deposition of that witness, the judge puts a question. In respect of that reply, you have to take a leave. But if the prosecutor produces a witness, you can exempt examination only under 139. That he is summoned to produce it. But if he is examined, you have right. So when he was summoned to produce documents and he was examined, irrespective of the examination being made by questions of the judge, your right to cross-examination was always there. We don't know, Mr. Chaudhary. There are certain doubts in my mind with regard to clarity on this point. You have not really addressed, we will not decide on that. Because you have no grievance as the appellate. No, sir, no. Where is your ground? Where is your objection? You have never taken a point. In your grounds of appeal, you have not taken a point. You have not argued at any point of time in your big fat written argument that this evidence is inadmissible because I was not given a right to cross-examine. You have accepted that this is 165, so cross-examination without the leave of the court is not permissible. I did not ask for leave, so it is not there. So we leave it.
I asked for leave, it is also there.
Where is it? Where have you asked for leave?
Orally, I asked for leave. There is no application.
Well, in your ground of appeal, have you said that you orally asked for leave? In your written arguments, have you said that you orally asked for leave? You won't be allowed to resurrect cases where you have not made out an argument. What I am saying is theoretically, I have serious reservations as to whether this examination was at all under 165 or it was in the nature of a prosecution witness. It would be either under 311 that the judge was summoning a witness for or he was a person who was brought by the prosecutor because the judge required certain documents. That power was exercised under not 165, under 311. 311 of the Code of Laws for production of the CDRs. And in exercise of that powers, when the judge summoned those documents, a witness came. If he just produced the documents, no problem. He was brought to the witness box. Immediately, the right of cross-examination germinates. Irrespective of whether the questions are put by the judge or the prosecutor. The judge is not a prosecutor. If he puts a question incriminating fact, he has a duty to give you an opportunity to process. You have not taken that point and we will not go into it. Yes, please. Keep this on. When do you want to do? Friday? Friday, both of you are there. If you conclude quickly, we'll see. We will not give a specific time, we will say after the month. I'll try to wrap up on it. Also, you have many things to answer. During the non-examination of the responsible officer of the service provider, be protected by the law declared in Sonu. Or after Kotkar Pandit, Sonu cannot come to your aid and protect the evidence. That if you cannot satisfy that Sonu does not take care of the situation, because Sonu says if you do not raise an objection, it is admitted. Then Ajit Kotkar Pandit says that it's not a question of admissibility, objection or anything, it's a question of admissibility. And admissibility is a fact to be proved. If admissibility is not proved, then it is inadmissible. It is something like saying that if a statement before a police officer in confession, no objection is raised, will it become admissible? No, then it is inadmissible. The fact to be proved is that the electronic devices were working properly and it has been produced in official course of evidence. That fact the police officer knows.
On the operator budget.
This is something which we would like you to indicate how far Sonu will apply, because we found the dissenting view is founded on Sonu. You have to address it. You did not address us. You address us on that. You can see what is the PW14. I will give it. PW14 is finished. There is a telephonic conversation, but the corroborative evidence is not. Because of failure. And disclosure statement, whether it's a disclosure statement. So far as the jewelry is concerned, Mr. Chaudhary is rightly pointing out just identification verification section. What about the weapon? The weapon, his argument is blood group was not tested with the blood. Justice Somensen has indicated there is another species of body, that is the PMB. Says good. And on his showing the cookery with human blood was that you can rely on those circumstances.
Right.